Milord, a very honest request, Milord. Item number 63, Milord. These are Milord poor Milord dalawalas. Milord, they are hawkers basically. But all of their shops have been closed, despite Milord several orders of this court. But if some precedence could be given on any day, Milord,
it is in the appellate side.
In the appellate side list.
Okay, we will make a note of it.
I have served notice.
Permit to mention on appeal matter, urgencies for extension of interim order. Your Lordship, the interim order has been passed on by this Honorable Court on 12th July, and we have filed an extension, and I am paying for upgradation notice.
My Lord, I am praying leave to file the appeal without certified copy.
Leave grant.
Similar prayer.
Similar prayer.
Similar.
May I permission the contempt of application? We have filed a contempt application. Let the matter be appear on 14 August. So your Lordship fix the matter similar matter.
Yes.
Milord, praying for Milord's kind leave to mention one matter, Sexa 02 of 2007. This relates to the spinning mill matters, which Milord's order has already been disposed of. But this matter was not taken up till date. Now, the difficulty and urgency is the respondent number 4 has gone before the writ court against our recovery proceedings, Milord. Since this matter is pending particularly. So, Milord.
Inclusion in the list.
Please call the list.
Original side daily list item number 1.
Service is complete, Lord. There is a delay of 12 days. Affidavit.
31st July, sir. I have copy.
On what date notice was served?
31st of July, my Lord.
31st of July. But who appeared for the SSC before the
Lord,
tribunal?
some FCA, my Lord, appeared, no advocate.
Manish Tiwari. I think Pratyush Junjunwala normally appears. And where are the questions?
Lord, the questions, my Lord. The Lordship sees, my Lord, page 9 of the stay application, my Lord.
So this valuation report was not before the AO.
Not before the AO, my Lord, and if your Lordship goes, my Lord, through the order of the CITA, in fact, it was not before the CITA also. My Lord, the tribunal, my Lord, I have a feeling, my Lord, that the tribunal, my Lord, was going through some other brief, my Lord, has, my Lord, applied the law here. If your Lordship sees here, my Lord, right from the very beginning, my Lord, there has been a case, my Lord, of, if your Lordship kindly takes the tribunal's order, my Lord, page, my Lord, it begins at page 35. Kindly take, my Lord, page 39 once. Just to show, my Lord, how he has proceeded. My Lord, paragraph 7, aggrieved assessee is in appeal before the tribunal. Lord, this is the revenues appeal, number 1. Now, my Lord, kindly have a look at the other part. My Lord, page 42. Last part, my Lord, last paragraph. We note that the learned assessing officer had called for a valuation report in the original, in the course of assessment proceedings, which the assessee could not produce, leading to adverse view by the learned assessing officer. However, the same was produced before the CITA, who took cognizance of the same and called for a remand report from the learned assessing officer, who did not deal with it for expression of his views on the same. My Lord, this is absolutely wrong. My Lord, the CITA's order, my Lord, is there. Your Lordship will not find any whisper about any valuation report. And my Lord, there is a specific ground taken by us saying, my Lord, that the remand report was not related, was not called for in respect of any valuation report. My Lord, in fact, that should have been a substantial question of law. Your Lordship, kindly take note, ground number 7 in my memorandum of appeal.
Hmm.
And my lord, the assessee's submission, if your lordship reads, my lord, in the CITA's order which have been, my lord, my lord, extracted, my lord, there also, my lord, there is no reference to any valuation report having been furnished before the CIT appeals.
And this valuation report relates to some other,
No, my lord, it might relate to this, my lord. We do not know, my lord, because we were never given an opportunity, my lord. The learned tribunal for the first time finds this, and my lord, even otherwise, even if it is, my lord, presumed that it was placed for the first time before the tribunal, and my lord, the tribunal has, my lord, the capacity to look into it, my lord. Then also, my lord, in terms of your lordship's judgment, my lord, section 56(2).
It's 21. Page 21.
Yes, remand report.
Ah.
My lord, remand report, my lord, does not whisper about the valuation. That is my ground 7. My lord, 20 points were called for. Valuation report was not before the assessing officer. All the 20 points have been answered. My lord, it was all as to whether the company, my lord, since it has been registered under the Registration of Companies Act 1961, my lord, pertaining to Sikkim, therefore it is not covered. It will not fall under the purview of the Income Tax Act. My lord, those were the grounds on which, my lord, the answers were sought. And my lord, the CITA's order, my lord, is absolutely on it. My lord, CIT appeals order does not anyway say that I am satisfied with the valuation report or the valuation.
For the valuation report
Alright.
that's submitted.
You have heard so and so for the appellant. Notice has been served on the respondent, but none appears for the respondent. The affidavit of service is taken on record. There's a delay of 12 days in filing the appeal. We are satisfied with the reasons assigned in the affidavit filed in support of the condoned delay petition, and accordingly the delay is condoned. Application is allowed. Now you admit this appeal on the following substantial questions of law. Page number 9, page number 9 and 10, 1, 2, and 3. In addition, fourth question,
7th.
whether the learned income tax appellate tribunal erred in relying upon a valuation report which was allegedly furnished by the assessee before the CITA, but was not produced before the assessing officer despite being called for. And the fact being that in the remand report furnished by the assessing officer dated 19/3/2019, there is no query raised with regard to the valuation of shares. Question. So there will be 4 questions. No notice of appeal of whatever.
No query as regards the valuation report.
Hmm?
No query as regards the valuation
Report.
Yes,
No
because
query with regard to the valuation.
20 points, Lord, nothing about valuation report. The CITA's order does not even whisper, Lord, about the valuation report.
Let us see. Next.
Item number 2.
Grateful.
My lord, though I have sent, but
Service awaited.
service is awaited because my lord, on the website there is no report available regarding whether it has been served on. So I may come back after 1 week. My lord.
Await service of notice on the respondent. Await service of notice on the respondent.
Intercourt appeals item number 3.
My lord, Mr. Vipul Kundale would appear for the respondents. He is not in court. He won't be in court for the first half. He has some medical difficulties in his family. My lord, can it be not this week because he might not be attending court regularly this week for the rest of the week?
You can't manage.
No, my lord. There are no.
Why?
Huh?
Why you can't manage?
My lord, because I have not really read. I was also.
You had 1 hour. No?
No, my lord. Yes.
We came just for 10 minutes back.
Yes, my lord.
Lord, very simple issue, my lord.
Your objection was not considered.
My lord, what happened? I had denied the transaction. And AO time and again, he is himself not satisfied with the information because he is using the word prima facie. Looking at the bank account, he believes that I have received some accommodation entry and that party is receiving some rotation of fund is going on. Simply on that, with no statement of anybody, nothing. And I have denied the transaction, that I have not entered into any such transaction. And I had, before the single judge, I had taken the plea that no material was given to me as well. What is the basis of coming to the?
But in page 27, in the 148 AD order, if you come to para 5, the last line of para 5, but the assessee, that is in italics, the allegation in the show cause notice.
Page 25, my lord.
Page 27,
Achha.
para 5,
My lord.
after the italics portion,
My lord.
but the assessee did not submit any documents, evidence, bank statement, profit and loss account, balance sheet and supporting document to substantiate the alleged transaction made, and not only with so and so, but also with other concerned during the financial year. In the absence of any conflict, the alleged transaction stands at so and so and escaped assessment, failure on the part to truly and true correctness.
Lord,
But what is your reply?
my reply, my lord, is at page number 23. And first part, I am reproducing the notice. And second part, my lord, at page 24, last para. We have not entered into any financial transaction with so and so during the financial year 11 to, that is, neither our company received any fund or paid any amount to BSR Finance and Construction Limited during financial year 18-19, and there was no any financial transactions in between our company and BSR Finance during so and so. There is no question of any income chargeable to tax has escaped assessment in respect of financial. My lord, kindly see the notice, my lord. At page number 21 is the annexure to notice under section 148 small b. My lord, first para says the credible information was received from reliable source. Now, source here has not been spelled out. There are two accounts highlighted, namely so and so with RBL Bank Limited, wherein the reporting authority has pointed out the alert in the bank accounts in the name of the entity. Glancing over the pattern of transactions carried out through the bank account so and so, it is found that the nature of transactions prima facie denotes layering and routing of funds to be finally credited to the main beneficiary, for which the whole process of circulatory movement.
But if they give the bank statement of this BSR Finance, no, if the bank statement reflects,
that is also not given to me. A specific averment has been.
Is there any attachment to this annexure?
Nothing, my lord. That I have taken a specific ground before the single on learned single.
Where is the writ petition?
Lord, the writ petition is at page number 44.
Which is that ground you have said?
My lord, ground number 3 starts from page 13, my lord, grounds. For that, the respondent authorities have failed to consider that there is no material on record indicating escapement of income, inasmuch as no such material has been handed over to the petitioner nor annexed to the notices issued order.
Why don't you give this material and then fix it?
My lord, may I pray for a short passover? I have been given to understand that Mr. Kundale is on his way. He will come.
Pass.
Item number 4.
Same prayer, ma'am.
Pass.
For admission, item number 5.
Not same. Mr. Kundale is there.
No, this is assessee's appeal. Item 5.
Yes.
May please. But I am led by Mr. Kunduli. Well, it's only. Well, I may point out that in the memorandum of appeal, there are 4 questions. But in the stay application of those, there are 2 questions, but at the bottom of they may kind of be ignored. No, they shouldn't have found place. No, at page 10,
Yes,
the questions 5 and 6 shouldn't have been there. No, they're not in the memorandum of appeal.
so they are not relevant.
Not relevant. Now, the only two paragraphs of the order of tribunal, paragraphs 11 and 12. No, it's an order of remand. But no, the tribunal says that the Commissioner Appeals granted relief without discussion and without indicating basis. But there is a those observations are in my humble submission. The order of the Commissioner does not read like that. If I can take my lords to the order of the Commissioner, at page 29. But if I may just indicate first the legal question, but in the case of non-resident shipping lines, they are assessed on the basis of every voyage. But under section 172, before the ship leaves the shores, the tax has to be paid or arrangement has to be made. The assessment is made with reference to every voyage, and they have the option later on after the close of the year to say that no, please make an assessment for the whole year, that we are liable for less tax or whatever. But so therefore the TDS tax deduction provisions do not apply. And there's a circular of the board which says that the provisions of section 194C and 195 do not apply to these non-resident shipping lines and their agents. So these payments were made, the assessee claimed that these payments were made to non-resident shipping lines or their agents, and no tax was required to be deducted at source. But that is the background. Now, kindly take the Commissioner Appeals order at page 29. The bottom half, ground of appeal number 4, where that discussion starts. It's actually 4 crore 61 lakhs. There's a typographical error, it was corrected. Now, if my lord is pleased, if my lords are pleased to look at this table, out of this table, there are the assessing officer trying to take page 30. But the second and the third, the assessing officer allowed. So these were therefore not in controversy. The
Second and third.
Yes, but Confreight Shipping.
Confreight Shipping, APL India.
Yes, he allowed. Now, there are 3 others, which the Commissioner Appeals did not allow. That is page 29, the first one, transport system.
No, which the that is at page 29.
29.
Transport system,
which was not allowed.
CIT rejected.
Yes, and then he also rejected the 4th at page 30, AL Logistics.
APL. AL Logistics.
AL Logistics and VN Logistics, 3,46,000. So these were the 3 he rejected.
Assessee was not on appeal against that.
No.
So this leaves us with MSC agencies, Hajin Shipping, AL Logistics,
yes,
so and so shipping line, overseas container, and Maersk line.
AL Logistics was disallowed by the Commissioner of Appeals. We are left with actually 5, that MSC agencies, Hanjin Shipping, Samudera Shipping, overseas container, and Maersk line. These are the 5. Now, I will show that the Commissioner has specifically discussed Hanjin Shipping, which is 2,74,000. At page 30 at the top, I'll show where the discussion is. And with this Maersk line, 4 crore 50 lakhs. These 2 are specifically discussed. And the other 3, I must be candid, there's no specific discussion, but these 2 amount for a very substantial amount. Hanjin Shipping is 2,74,000 and Maersk line is 4 crore 50, which is the bulk of the amount. With the disallowance is 4 crore 56. But there is discussion on 4 crore 52, 53 lakhs. The other 3, I'm going to kindly take the discussion at page 31.
Yes.
But in fact, if I may trouble my lordship, page 30 also, because not this, what was the SSC submission? But the page 30, the appellant CR has made written submission as following. Now, the reason I wanted to show this was not, one, there is reference to tribunal decision in the case of Madhu Jayanti, which was affirmed by our court in appeal. There's a reference of that. There's reference also to another tribunal decision, associated pigment. There's mention of bills of the shipping lines which were also furnished before the Commissioner of Appeals. And then SSC himself pointed out that 3 of them are not agents of non. So those 3 which I pointed out, the Commissioner disallowed. The SSC himself pointed out that these 3 are not. Then with the discussion at page 31.
So Hajin Shipping in page 31, first paragraph,
Yes, ma'am.
and he has discussed both. And held that therefore such payments are subject to deduction under 194C.
Those are the 3 minutes. But Hanjin, he's discussed at page 31, the opening paragraph.
No, what is the finding with regard to Hajin Shipping and Maersk Line India?
Kindly see page 31. 7th line from the top middle.
Yes.
From the perusal of the material on record, it is observed that the payment of shipping charges of this amount is wrong. It is 2,74,000 was admittedly paid to Hanjin Shipping, which is agent of non-resident shipping company Hanjin Shipping. Copy of order under section 197 dated 29 March in the case of Hanjin Shipping by the DDIT International Taxation, certifying that provisions of section 195 and 194C of the Act are not applicable in respect of any payments made to Hanjin Shipping, Korea, or their agent Hanjin Shipping India Private Limited. Similar payments of shipping charges were found to have also been made to Maersk India Private Limited during the previous year ending 31st March 2020. In addition, payment of shipping charges. So then he goes into the other things. Then he discusses the law.
But has he given a finding with regard to Hajin Shipping and this Maersk?
These are his findings, because he refers to the material on record to say that there's a
certificate.
And if my lords are pleased to page 198.
But he could have dealt with one by one.
Yes, he could have. He has discussed 2. Page 198, can you see at the bottom on the right-hand side? Payment in favor. Please note that we have order issued under section 197 of the IT Act. We are requested not to deduct any tax from this invoice. Please find the order posted on our website, so and so. So that is the order which the Commissioner has
noted.
And then kindly see at page 206. This is the invoice note of Maersk Line. Kindly see at page 207. But from the bottom, the 4th line.
TDS is not applicable as per circular number so and so.
And kindly have a look at that circular, which is at page 16.
So probably the tribunal thought it has bulked up the issues. If you go through page 31, though he refers to that certificate, he doesn't give a specific finding that in respect of these 2 companies, TDS should not have been directed. He doesn't put a full stop. Then so if you, of course, if you read the paragraph from perusal of the material till 31.3. So that shows that the finding is in favor of the SSC.
Yes, because in the operative part, he refers to the decision of the tribunal in associated pigments, and then he says was not
justified in making disallowance amount of 4.56 paid to the agents of non-resident, whereupon provisions of so and so were not applicable. Respect of balance payment so and so so and so. Accordingly, a directed to delete the so and so disallowance of 40 AI is restricted to 492 this term. So it can't be said that in respect of these two companies,
Lordship, my lord.
there is
Because
no,
my lord, when the matter goes back before the assessing officer, my lord,
He
he will
will
be
open-
troubled as to what more am I supposed to do? My lord. There is the circular of the board
finding is there.
that decisions are
But in respect of the other two,
other three, my lord.
other three,
Other three, my lord, that is one is my lord, this Samudera shipping,
no, that is, first is MSC agencies,
lordship, my lord,
MSC agencies.
and then
Sam-
Samudera.
Samune-
It is Samudera, my lord. SAMUDERA.
Samudera
Samudera.
shipping and overseas container.
These three, my lord, there is no discussion.
There's no discussion.
But that, to that extent, the tribunal is right. But not, but the bulk of the amount is in Maersk. Now, when the matter will go back to the assessing officer, he will wonder as to what else is he supposed to do.
We can restrict the remand to these three companies.
Lordship.
Well, please take note. This appeal by the assessee filed under section 260 cap of the Income Tax Act 1961. Within bracket, the act is directed against the order dated September 23, 2022. Only push this. Make yourself comfortable.
Well, only one thing is not produced any papers. One of the
But the
finding is,
certificate is there. Certificate is there in the invoice itself. That is,
but those have not been produced before.
no, it is, that has been considered by the CITA, but of course, the tribunal in page 235 para 12 says detailed factual finding now. We'll substantiate. So and so dated 23rd September 2022, passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA numbers 345/KOL/2019 for the assessment year 2012-13. The assessee has raised the following substantial questions of law for consideration. Page number 10 and 11, 1, 2, 3, 4, 5, 6 not required. We have heard so. The short question involved in this appeal is whether the learned tribunal was justified in remanding the matter back to the file of the assessing officer to consider the disallowance which has been consider the correctness of the order passed by the Commissioner of Income Tax Appeals, by which the Commissioner granted partial relief in favor of the assessee in respect of certain disallowances concerning non-resident shipping lines. In the order of the tribunal, sorry, the relevant paragraphs which concerns the subject issue are paragraph 11 and 12 of the order of the learned tribunal, from which we find that the learned tribunal was of the view that the CITA has not given any detailed or factual finding as to which of the payees, WES, were foreign shipping companies or their agents, and simply relied upon the list given by the assessee without discussing as to which of the payees were resident companies and which of the payees were non-resident companies, and no basis has been given for his conclusion. With this finding, the learned tribunal had remanded the matter to the assessing officer on the issues which have been, on the limited issues which have been indicated in paragraph 12 of the impugned order. To examine the correctness of the finding rendered by the learned tribunal, we have carefully perused the order passed by the CITA dated 6th September 2018. The subject issues have been discussed in ground number 4. The assessee company paid shipping company charges to the following companies. Sir, there's a tabular column. in page 29 and 30, please extract the copy. Out of the out of the 10 companies, the assessing officer granted relief to the assessee in respect of
Serial numbers 3 and 4, my lord.
no. He allowed for Confreet and
APL India, my lord. 3 and 4, my lord.
yes.
Third and fourth.
They granted relief to the assessee in respect of the shipping company charges paid to Confreet Shipping and APL India Private Limited. The CITA rejected the assessee's appeal in respect of the shipping company charges paid to 3 companies, namely Transport System Private Limited, AL Logistics, and VN Logistics. The assessee was not on appeal against these findings of the CIT. This leaves us with 3 companies,
5.
five companies, namely MSC Agencies Private Limited, Anjin Shipping Company Private Limited, Samudera Shipping Line Private Limited, and Maersk Line India Private Limited. In the order passed by the CIT,
But overseas,
Overseas Container Line Limited and Maersk Line India Private Limited. On a perusal of the order passed by the CIT appeals, we find there is sufficient discussion as to why the CITA was convinced that relief should be granted to the assessee in respect of Hajin Shipping Company Limited and Maersk Line India Limited. It is noted by the CITA that on perusal of the materials available on record, payment of shipping charges was admittedly paid to Hajin Shipping India Private Limited, which is an agent of non-resident shipping company. And the copy of the order under section 197 dated 29/3/2017 in the case of Messrs. Hajin Shipping India Private Limited by the DDIT within bracket international taxation bracket close 3 within bracket 1 Mumbai, certifying that provisions of 195 and 194 capital C of the Act are not applicable in respect of payments made to Hajin Shipping Company Limited or their agent, Hajin Shipping India Private Limited. This finding, in our view, takes note of the relevant order passed by the DDIT international taxation. This finding is duly supported by a note mentioned in the invoice dated 31st May 2012, raised by Hanjin Shipping Company Limited, wherein it has been clearly stated that they have an order under section 197 of the Act, and a request was made not to deduct any tax on the said invoice. Therefore, we find that so far as the payment of shipping charges to Hajin Shipping India Private Limited was rightly construed by the CITA and held that no tax need to be deducted at source. With regard to Maersk Line India Private Limited, that CITA noted that similar payments for shipping charges were found to have been made to the said company during the previous year ending 31/3/2012. That apart, the learned tribe, the CITA, after placing reliance on the decision of the tribunal, coordinate bench of the tribunal, in the case of DCIT Circle 10 Kolkata, versus Associated Pigments Limited, comma, the CITA concluded that the assessing officer was not justified in making disallowance of the amount of rupees 4,56, 40, 926 paid to the agents of non-resident shipping companies, whereon the provisions of section 195 and 194 capital C of the Act were not applicable. Thus, it cannot be stated, full stop. Further, we note that in the invoice dated
30th April 2012, page 206.
where is the date?
The top Millard, below import invoice number, invoice date 30th April 2012.
Invoice number is there,
Just below that,
page 207.
206.
At the 206, sir. Yes. Invoice dated 5th May 2012.
30th April, no, that's the due date of the invoice.
Sorry, 30th April 2012. It is seen that there is a specific mention that TDS is not applicable as per circular number 723 dated 19/9/1995. Thus, we are of the view that the CIT rightly granted relief to the assessee in respect of payment of shipping charges to those two companies, namely Hon'ble Shipping Company Limited and Maersk Line India Private Limited. The learned tribunal was right insofar as the payments made by the assessee to MSC Agencies Private Limited, Somidera Ship Line Private Limited, and Overseas Container Line Limited. There is no specific discussion by the CITA while granting relief to the assessee. Therefore, to that extent, we agree with the finding rendered by the learned tribunal that the issue has to be reconsidered by the assessing officer as fresh only in respect of those three companies as mentioned above. In the result, the appeal is partly allowed and the finding of the learned tribunal insofar as it relates to the payment of shipping charges paid to Hon'ble Shipping Company Limited and Samudera and Maersk Line India Limited stands set aside and the order passed by the CITA is confirmed. Full stop. The order of remand passed by the learned tribunal is confined to the payments for the shipping companies charges for two MSC Agency Private Limited, Samudera Shipping Line Private Limited, and Overseas Container Line Limited stand remanded to the assessing officer for fresh decision in terms of the direction issued by the learned tribunal. The appeal is partly allowed. No, appeal is accordingly partly allowed. Consequently, the substantial questions of law are left open.
I'm grateful, my lord.
We'll take up that passover matter, sir.
Passover matter, item number 3.
Sir, in this, they have challenged the 148 DER. His contention or reply to show cause notices, sir, I have not done any transaction. But if suppose they had issued a notice or another notice under 142 or something and enclosed a copy of the bank statement of that BSR, what is that?
BSR. BSR Finance.
BSR Finance.
Well,
You could have fixed him easily. We will remand it, ask them to give that statement or corroborative record to show that this person, this assessee has transacted, because he says in no uncertain terms that there was no financial
he
transaction.
says there is no financial transaction with BSR in that year. The assessing officer says that no, there is a transaction of that amount. Now you are specifically saying this, that it is not happened with this person. Then he ought to have showed through documents what the transaction is. This is what
Initial onus is on the department to show Caesar this amount has been reflected in the financial
That's correct.
statement of BSR
That's
Finance. Explain.
But my lord, the ownership's at the point when the moment he says that no, this, I have not transacted with this person at all, but transaction is still there, then you have to show, he has to show that through his bank documents, if he had given his bank documents,
No, if you see, please take page 21.
my lord.
This is an annexure to the show cause notice.
My lord.
Credible information was received from reliable source. They say source not disclosed. They keep it aside for the moment. There are two accounts highlighted, namely so-and-so with RBL
Yes.
Bank. While reporting authority has pointed out the alert in the bank accounts in the name of the entity. Glancing over the pattern of transactions carried out through the bank account of, that is BSR Finance,
My lord.
it is found that the nature of transactions prima facie denotes layering and routing of funds to be finally credited to the main beneficiary, for which the whole process of circulatory movement is created and effected through transaction. In the instant case, it has been found BSR Finance is merely a paper and shell company. So that is a different finding.
Yes, ma'am.
So you will have to fix this as a C, that there was a transaction with, in this bank account 6048 of BSR, which would denote layering and routing of funds.
My lord. My
So
lord.
you furnish that statement or some material based on which you came to that. But in fact, he should not have used the word prima facie.
Right.
It's an annexure to the show cause notice. So you, whatever little information you are available, you put it to him. We will direct him to substantiate his plea that he has not transacted at all. Let him substantiate.
There is no harm to the revenue by this order. I am prepared to go for further. If AO puts me in the dock, I am prepared to face him. Where is the problem? And my lord, he should point out which entry belongs to me. That information has to be.
Or if you say that suppose the records are bulky, he can be allowed inspection. Let him inspect, and based on that, let him give his reply. And along with that bank statement, whatever records he want to produce.
And he should point out.
No, my lord, that just talking to myself, my lord, questioning myself. When such an allegation has been given, put on him, allegedly, why did he not put in the document showing that this is what this amount was and this is what I have done?
My lord,
That he
this
should
is
have
a-
done. Now he's talking about merits at this stage. My lord will kindly consider this is 148 AD stage.
I
He's
cannot
going
prove
on
the
merits
negative, my
today.
lord. How can I prove the
Supreme Court
negative?
also derides that he will get his opportunity at the reassessment stage. That is something, my lord, in
No.
Anshul Jain, my lord will remember that.
If there is an allegation of escapement of income from tax, the initial onus is on the department
Initial owners,
because it's a case of reopening.
my lord.
The regular assessment 143.3, he says you put a questioner, he's not able to explain, that's a different matter. But so far as reopening is concerned,
My lord, one thing may I point
My
out?
lord, there's a difference between the two acts now. Here it is suspicion, my lord.
He is
This act
accepting.
says suspicion.
And how can
On
you?
that, my lord, kindly reads this annexure once again with me.
yes.
Kindly. A credible information was received from reliable source against Messrs. BSR Finance and Construction Limited. There are two accounts highlighted, namely so-and-so and so-and-so with RBL Bank, wherein the reporting authority has pointed out the alert in the bank accounts in the name of the entity. So here the entity is here.
Alert in the
The
bank
petitioner.
account of BSR Finance.
Yes, wherein the reporting authority has pointed out the alert in the bank account in the name of the entity. Glancing over the pattern of transactions carried out through the bank account. So there is a finding here that they have
All
done this.
No, correct. All this allegation
Yes.
are que BSR Finance. He has not examined his accounts. He examines the accounts of BSR Finance because BSR Finance is a shell company.
Yes, my lord.
And he says that they are prima facie denotes layering and routing of funds.
Yes, my lord.
So to fix this as a C, you
Yes.
produce some credibility. See what Supreme Court says, there should be a live link, something for him to explain. It can be suspicion. Could be. But there should be a reasonable basis for such suspicion. So you say this because of this record, and you are actively participating in this layering or routing of funds, which comes back to the main beneficiary.
My lord will kindly see the third paragraph once.
Please.
It is seen from the above information that the SSE has entered into financial transaction of the value of 1 crore 15 lakhs.
That's all. Very simple. You
lord.
furnish that document alone or that information.
My lord kindly allows me to finish that paragraph. Financial transaction of the value of 1 crore 15 lakhs during the year 2018-19 relevant to 1920, which suggests that the income chargeable to tax has escaped escapement in respect of the financial transactions made by the SSE to the tune of so and so. You are therefore requested to show cause as to why a notice under so and so should not be issued on the basis of the above narrated evidence-based information, which suggests that income chargeable to tax has escaped assessment in your case for 1920 amounts to 1 crore 15 lakhs. Now, my lord, what my humble submission is that.
Okay, can we just read his reply and then you?
Yes, my lord.
Page 24, last paragraph.
24. Last paragraph.
In this regard.
My lord, he has given the one paragraph reply to this.
Yes.
In this regard, this is to say that our company had not entered into any financial transaction with Messrs. BSR Finance during the financial year 18-19. So he specifies that there is nothing in 18-19 relevant to the assessment year 19-20. That is, neither our company received any amount from or paid any amount to Messrs. BSR Finance Construction Limited during the financial 18-19. And there was no any financial transaction in between our company and BSR during the financial year 18-19 relevant to the assessment year 19-20. There is no any question of any income chargeable to tax has escaped assessment in respect of financial transaction with the said company. Since there was no any financial transaction, so he consistently says there is no transaction with BSR, but he doesn't say anything about 1 crore 15 lakhs. He doesn't say that there is no transaction relating to 1 crore 15 lakhs here. He says there is no transaction. Very, very smartly drafted, although it seems the English is different, but very smartly drafted one paragraph, which says that no, I never had any transaction with BSR in 18-19 relating to 19-20. But he never says anything about that 1 crore 15 lakhs.
It is deemed that once he says that I have never transacted,
which is why I'm saying that it is a very cleverly drafted paragraph.
Now you please come to page 27, para 5.
My lord.
AD order.
No.
He extracts the portion of the show cause notice that is in italics.
Yes, my lord.
Last line. But the assessee did not submit over the page any documentary evidence, bank statement, profit and loss account, so on. So to substantiate the allegation, so on. So what he could have done is 148A procedure he could have resorted.
Milord,
If he had initiated the inquiry, you could have fixed it.
Milord, he has categorically recorded that no such inquiry is required in this case.
That is mistake he committed, sir. You are only postponing the date, that's all.
No, I am, Milord, I have no difficulty, Milord, to appear and to substantiate. Only thing is that there has to be.
Today is saying so.
Always I am saying that.
So. He never did that.
I said at that time
That's
also I have no transaction.
And
Why,
my
what
humble
material you had, why you did not
Let you
produce?
substantiate that in the reassessment.
Why?
If it is clear, he has his document, then why is he scared of showing those?
Let me explain, Milord. Milord, this provision has come in to reduce the litigation, Milord. That courts are saying time and again. Supreme Court is saying so. And now they want to elongate and what they have done, Milord, once assessment is reopened, they can inquire each and everything, Milord. After 5-10 years, Milord, my professional receipts, they will ask for details 5 years back, wherefrom I will produce the evidence. So I will be finished, Milord. So this cannot be allowed, Milord. And this is sacrosanct.
My lord will kindly come.
Milord has
come back
passed
to page
order,
24.
Milord, let me complete. Milord has passed order that information suggesting escapement of income That cannot be lightly. This is a jurisdictional point. Before entering the door, you have to prove it. And this, my lord, has categorically stated, my lord, I am submitting this order, and there are Delhi High Court and even the Bombay High Court that 148A is required in such circumstances. You make inquiry. Lord, this is the.
Lord, may I then place the Supreme
Let
Court?
me complete. Let me complete.
This is the matter where Mr. Muraka appeared.
No, my lord, I appeared in this
Oh, you had
case.
appeared.
My lord, even their CBDT,
Copy the-
they are saying, my lord, at page 3, lordships have quoted CBDT circular. They are saying you make inquiry first. Because, and they are conceding that there is mistake in our data feeding. It is CBDT is conceding this fact. My lord can see at page 4. In the subpara 1I, it is not out of place to mention here that information made available, data uploaded by the reporting entities may not be fully accurate due to inter alia, error of human nature, technical nature, etc. So then finding of my lords, from the above, it is clear that it has come to the notice of CBDT that in several cases, information made available, data uploaded by reporting entity are not fully accurate due to error of human nature, technical. Therefore, the department was advised to effect due verification and opportunity of being heard given to the taxpayers before initiating proceedings under 147. Then, my lord, at page 6, my lord, just below the italics is the finding portion of Divya Capital in by Delhi High Court. My lords have pointed, has given this finding. As pointed out in the aforesaid mentioned decision, the term information in explanation 1 under section 148 cannot be lightly resorted to so as to reopen assessment, and this information cannot be a ground to give unbridled power to the revenue. So, my lord, and even there are subsequent decisions, my lord, reading Ashish Agarwal, my lord, Honorable Bombay High Court, in case of Anurag Gupta, under similar facts and circumstances, my lord. Even here, no response was submitted by the SSC in this case. This is recorded at para 5 of this order.
Yes, page 3.
Page 3, my lord. Then page 6, my lord, no material supplied. I'm sorry.
This is, you have given me Bombay High Court, 10184. Anurag.
Finding at page 7, last para.
Yes.
In the present case, admittedly, no material has been supplied to the petitioner, notwithstanding the fact that there was material available with the AO, as can be seen from the order. In my case, there is no material even in the order. This was in the shape of a statement recorded. There is no statement recorded in my case. Then last para, it goes without saying that providing information to the petitioner without furnishing the material based upon which information is provided would render an SSC handicapped in submitting an effective reply to the so-called notice, thereby rendering the purpose and spirit of 148AB of the Act totally elusive and ephemeral. The fact that material also was required to be supplied can very well be gauged from the clear direction issued by Honorable Supreme Court in Union of India versus Ashish Agarwal. Lord, what more is required? And my lord, I am prepared to go back. I am not running away. If you have material, give me and text me. I have no problem. Follow the principles of natural justice. 148A, the spirit of 148A is this. That is that is the way in which you can reduce the litigation.
My lord will kindly see.
Why should I come before the Honorable High Court and clog the docket of the
My lord
Honorable?
will kindly see the 148AB. in the 148 AB, the annexure, he says that no information has to be credible and all that. Particularly the Bombay High Court that he was referring to. My lord, here, in this case, if my lord sees page 21, credible information was received from reliable source against, which is why I pointed out, there are two, against so-and-so, there are two accounts highlighted, namely so-and-so with so-and-so, wherein the reporting authority has pointed out the alert in the bank account in the name of the entity, glancing over them. My lord will kindly see this. Glancing over the pattern of transactions carried out through the bank account so-and-so, it is found that the nature of transactions perhaps denotes layering and routing of funds to be finally credited to the main beneficiary, for which the whole process of circular movement is created and affected through the transaction. So here, my lord, the situation is different. Information was got, alert was given. Thereafter, there has been a proper research of that particular account. He has done his inquiry, he has done his verification. Based on that, he has given this 148 AB.
Actually,
asking him.
correct.
Asking
The
him.
first paragraph
My lord.
is a statement concerning BSR finance
My lord.
with no specific allegation connecting the SSC. Paragraph 3 is the matter
Yes.
connecting the SSC.
Yes, my lord.
So it is seen from the above information. Please tell him what is that information. That is all is required.
No, my lord. Here, in this case, the above information is the first paragraph.
First, that
It becomes
above
the first
information,
paragraph.
there is some material.
No.
Please give him that material.
My lord, this is where I am coming from. My lord will kindly see the account number has been given. We have said that from this account number, we have found that these circulatory transactions are made. And now from this information, my lord will see. So, my lord, if this is correct, then from this account, he can straight away say that there is nothing with this particular account number. These are my bank statements. There is nothing with this account number on this. He merely says there is nothing with BSR. He doesn't say there is nothing with the bank account. There is nothing with anything connecting with.
Clever drafting.
Very cleverly drafted paragraph there, my lord. But that apart, my lord, I would respectfully submit, my lord, this in my humble submission is a matter of merit, not jurisdiction. Now, my lord, with Supreme Court, I rely on this particular judgment, my lord, order, my lord. My lord, at this stage, it's a short paragraph, my lord. The Supreme Court says that when the question of merits, jurisdiction, I can understand there are numerous jurisdiction points at different stages that SSCs come with, my lord.
We'll consider.
Point of merit, if this is the merit, my lord, my humble submission, that he can agitate this point before the reassessment stage.
This intra-court appeal by the writ petitioner is directed against the order dated 8th June 2023 in WPO 1119 of 2023. The appellant had filed the said writ petition challenging an order passed by the respondent under section 148 capital A within bracket small d of the Income Tax Act 1961 dated 13th April 2023 for the assessment year 2019-20. The learned single bench had dismissed the writ petition on the ground that
Page 68.
that the petitioner has ample opportunity of raising all contentions in the reopening proceedings pursuant to the notice issued under section 148 of the Act dated 13/4/2023. Agreed by such order, the appellant has filed the present appeal. We have heard. The respondent assessing officer issued notice under section 148 capital A within bracket small b of the Act dated 11/3/2023. In the annexure appended to the said notice, it had been mentioned that credible information was received from reliable source against Messrs. BSR Finance Construction Limited. There are two accounts highlighted, namely 40900 306048 and 134492 with RBL Bank Limited, wherein the reporting authority has pointed out the alert in the bank accounts in the name of the entity. The assessing officer states that glancing over the pattern of the transactions carried out through the bank account 40900 30648, it is found that the nature of transactions, prima facie denotes layering and routing of funds to be finally credited to the main beneficiary, for which the whole process of circulatory movement is created and effected through the transactions. Further, it is stated that BSR Finance and Construction Limited is merely a paper/shell entity used as a conduit for layering of funds. It is further alleged that from the within inverted comma above information, above alone inverted comma, that the assessee has entered into financial transaction of the value of rupees 115,000,000 during the financial year 2018-19 relevant to the assessment year 2019-20, which suggests that income chargeable to tax has escaped assessment in respect of the financial transaction made by the assessee/appellant. The appellant was directed to show cause as to why notice under section 148 of the Act should not be issued on the basis of the evidence-based information which suggests that income chargeable to tax has escaped assessment in the hands of the assessee. The assessee submitted the reply on 17/3/2023, stating that they have not entered into any financial transaction with BSR Finance and Construction Limited during the financial year 2018-19 relevant to the assessment year 2019-20. That is, neither the assessee received any amount from or paid any amount to BSR Finance and Construction Limited during the relevant financial year, and there was no financial transactions in between the assessee and BSR Finance and Construction Limited during the financial year 2018-19, and therefore there is no question of any income chargeable to tax escaping assessment in respect of the financial transactions with the said company. Therefore, the assessee requested that action should action should not be initiated under section 148 of the Act based on incorrect information. After considering the said reply, the assessing officer has passed an order dated 13/4/2023 under section 148 capital A within brackets small d of the Act. The operative portion of the discussion/conclusion is in paragraph 5 of the order. After extracting certain portions from the show cause notice in paragraph 5.1 of the said order, the assessing officer states that the assessee did not submit any documentary evidence, bank statements, profit and loss account, and balance sheet as supporting documents to substantiate the alleged transaction made not only with BSR Finance Construction Limited, but also with any other concern during the financial year 2018-19 relevant to the assessment year 2019-20. Therefore, the assessing officer concluded that in the absence of any concrete evidence, the alleged transaction at rupees 1,15,00,000,000 has escaped assessment, and there is failure on the part of the assessee to disclose true and correct facts of income chargeable to tax. Accordingly, the assessing officer held that it is a fit case to issue notice under section 148 of the Act. The said order was put to challenge in the writ petition. Apart from other grounds, the assessee mainly contended that the assessing officer has failed to consider that there is no material on record indicating escapement of income, in as much as no such material has been handed over to the assessee nor annexed to the notice issued or in the order which has been passed by the assessing officer. On a careful perusal of the annexure to the notice dated the 11/3/2023, it is seen that the credible information which is stated to have been received by the department from reliable source is against BSR Finance Construction Limited. The other observations also concern BSR Finance Construction Limited, which in the opinion of the assessing officer is a paper/shell company. In the third paragraph of the annexure to the show cause notice dated 11/3/2023, the assessing officer states that it is seen from the above information, inverted comma, that the assessee has entered into financial transaction of the value of rupees 1,15,00,000,000 during the financial year 2018-19, which suggests that income chargeable to tax has escaped assessment. Thus, the basis for issuing the notice under section 148 capital A within bracket small b of the Act is the information which has been received by the department from reliable source. Thus, the assessee was entitled to know the basis on which such allegation has been made, or in other words, assessee is entitled to be furnished with the relevant information based on which the assessing officer has come to the prima facie conclusion that income chargeable to tax has escaped assessment. Admittedly, this has not been done by the assessing officer. Not been done by the assessing officer. Full stop. That apart, the assessee has in its reply to the show cause notice, reply dated 17/3/2023, has stated that they have not entered into any financial transaction with BSR Finance Construction Limited and Construction Limited during the financial year 18-19. Therefore, if there was material available in the hands of the assessing officer to link the assessee with the said company, which in the view of the assessing officer was a shell company, such material ought to have been furnished to the assessee. This aspect touches upon the jurisdiction of the authority to invoke its power of reopening the assessment. At this juncture, it would be relevant to take note of a decision rendered by this court in the case of Excel Commodity and Derivative Private Limited versus Union of India and others, APOT 132 of 2022 dated 29th August 2022. In the said decision, the court took into consideration the circular issued by the Central Board of Direct Taxes within bracket CBDT dated 22nd August 2022, giving instruction to department officers with regard to uploading of data on functionality/portal of the income tax department. In the said circular, CBDT has stated that in several cases, information made available/data uploaded by the reporting entities are not fully accurate due to error of human nature, technical nature, etc. And therefore, the department was advised to give due verification and opportunity of being heard given to the taxpayers before initiating proceedings under section 148/147 of the Act. Admittedly, in the incident case, the procedure under section 148 capital A within bracket small b of the Act has not been resorted to by the assessing officer, as he was of the opinion that no such inquiry was required. Be that as it may, if
Small a, my lord, inquiry, in small a.
no such inquiry under section 148 capital A within bracket small a of the Act is required. Be that as it may, if credible information was available in the hands of the assessing officer, which prime facie shows that the assessee had financial transaction with the said BSR Finance Construction Company Limited, Construction Limited, during this relevant financial year, such information ought to be made known to the assessee for effectively submitting their objections/reply. More or less an identical issue was dealt with by the High Court of Judicature at Bombay in the case of Anurag Gupta versus Income Tax Officer Ward 1, Kalyan within bracket West, and others in WP number 10184 of 2022, dated 13th March 2023. The court, in the said case, the assessee did not file any response to the notice issued by the assessing officer under section 148 capital A within bracket small b of the Act. Nevertheless, the court took into consideration the facts of the case, referred to the decision of the Honorable Supreme Court in Union of India versus Ashish Agarwal, 2022 138 taxman.com 64 within bracket SC, and held that that in the absence of any material being supplied to the assessee, the assessee was handicapped in submitting an effective reply to the show cause notice, thereby rendering the purpose and spirit of section 148 capital A within bracket small b of the Act totally elusive and ephemeral. EPHEMERAL. Full stop. The learned senior standing counsel for the respondent revenue placed reliance on the order passed by the Honorable Supreme Court in the case of Anshul Jain versus Principal Commissioner of Income Tax and another in special leave to appeal C number 14823 of 2022, dated 2/9/2022. In the said case, the special leave petition filed by the assessee therein was dismissed. On going through the order passed by the Honorable Supreme Court, we find that the Honorable Supreme Court had pointed out that the assessee in the said case has a grievance on merits and therefore held that the same has to be agitated before the assessing officer in the reassessment proceedings. The facts of the case on hand is entirely different, as the assessee questions the jurisdiction of the assessing officer in assuming jurisdiction to reopen the assessment, and a specific plea has been raised that no information was furnished to the assessee based on which reopening was proposed. And in the absence of
information and material was also not furnished.
in the absence of any information being furnished to the assessee, nor any material being explicitly made known to the assessee while issuing the show cause notice, it is undoubtedly a case where there has been violation of principles of natural justice, and the court exercising jurisdiction under Article 226 of the Constitution is entitled to interfere with such order on such a technical ground without examining the merits of the matter. It is to be pointed out that in the instant case, the assessee has not canvassed the merits of the matter, but has expressed willingness to go before the assessing officer upon being furnished the requisite information, so that the assessee would be in a position to submit an effective reply. For the above reasons, the appeal is allowed. The order passed in the writ petition is set aside. Consequently, the writ petition is allowed, and the order passed under section 148 capital A within bracket small d of the Act dated 13/4/2023, and the consequential notice issued under section 148 dated 13/4/2023 as set aside, and the matter is remanded to the assessing officer with a direction to the assessing officer to furnish the relevant information based on which he has come to the prima facie conclusion that the assessee has entered into financial transaction of the value of rupees 1,15,00,000 during the financial year 2018-19 relevant to the assessment year 2019-20. The assessee shall be granted reasonable time to submit their reply on receipt of such information, and thereafter, after the assessing officer shall take a fresh decision.
My lord,
on merits
I may
and
be
in
given the
accordance with-
material also, or at least inspection of the material. Otherwise, my lord, information, so he will repeat the
That's
same thing.
In the event, the assessing officer is of the view that the material or information cannot be furnished in its entirety to the assessee, as it may contain details of other transactions which do not concern the assessee, the assessing officer is free to allow the authorized representative to the assessee to inspect those documents in the presence of the assessing officer in the office of the assessing officer. Next.
Item number 4.
And I am okay.
My lord, this is also against D order, and he is a very small SSC, my lord. A very narrow campus, facts are on very narrow camp. He's a salaried person, my lord. Salary of less than even 10,000 per month, and some odd accounting jobs he is doing. What happened, my lord?
It's an entry operator.
No, this is not a case of entry. That is not the allegation.
Operator.
My learned friend can say so, but EO and departmental authorities have no such case. What happened, my lord? He purchased some property, and the department, on the basis of that conveyance deed, got the information that the value is 30 lakhs, and you have not filed the return of income. The SSC filed his reply, and he stated that the source, AO wanted to know what is the source of the money. Then SSC submitted that because I could not arrange the finance, immediately I entered into an agreement for sale with other party, and that fund was used for purchasing of the property. And
In respect of another property?
Same property.
Oh, before
After-
purchase itself, he entered.
No, after conveyance deed was entered into, 2 days hence, he entered into agreement for sale.
So without receiving consideration, deed was executed.
No, deed, that draft was received from the subsequent party. That draft, that is mentioned in the memo of consideration also. Draft number, other details are mentioned. And all these details were submitted before the AO. Even agreement for sale was submitted before the AO. From their memo of consideration also specifies the draft was made in the name of the vendor of the conveyance deed. That I purchased the property, those vendors' name, the draft was entered in, purchased.
But why did you not file your return?
Then I submitted, my lord, computation of income, that my income was below taxable
So
limit.
that is on merits of the matter.
No, my lord, there is a jurisdictional point. Old law, there was a deeming fiction that if I don't file return under the old law, my lord, I had no case. If I don't file return, even if my income is below taxable, he can issue. He assumes the jurisdiction because deeming fiction is there. New law, my lord, there are 5 criteria specified as to what are the cases where income is deemed to have escaped assessment. Therein, they have not included that if my income is below taxable limit, that will be a deemed case of escapement of income. And for a justifiable reason, I may not have income chargeable to tax. Why should I furnish return of income, my lord? Why should I go through the rigor? Now, all these has been considered by the AO. Then he is saying that despite deed and other documents, you have not explained the source. But the source is apparent from the face of the record. What I have submitted before him, I can demonstrate that the source is clearly visible from there. my lord, may come to the agreement for sale, which is at page number 56. And at page 61 is the memo of consideration.
Page 56.
I had directed my purchaser to draw a draft in the name of these two persons who have sold the property to me.
But there is a gross difference between the sale consideration and the market
Below-
value of the property.
That case has not been made out in the so cause notice. Subsequently, that even in the T order, he is not referring to that there may be, the difference may be
No,
taxable.
no, in the show cause notice, it has been mentioned.
It has mentioned that table has been mentioned,
78 lakh 71,667.
is the market value,
It
but
has
he
been
is saying the source has not been, you have to prove the source. My lord, even assuming,
Where is the jurisdictional issue, sir?
my lord, even assuming, my lord, that source I
You
have,
pay the tax and be done with it.
my lord, I don't have money, my lord, I am a very small person.
Small person too, State Bank of India is your banker. DD drawn from Allahabad Bank. Where from some hanky panky.
DD, my lord, the person who purchased the property.
78 lakhs, my lord will kindly.
My lord,
Yes,
well,
yes, 78
my
lakhs.
lord,
He's
even
saying
that,
10,000
Consideration reflected
my
in.
lord, even then it is below 50 lakh. No, if the difference is
How
taken,
do we examine that, Mr. Agarwal?
my
in
lord,
this,
my lord, it
petition?
is on the face of the record. He is talking about, kindly come to the, my lord, notice under B at page 24, my lord.
At 25, you come to the show.
Page
Annexure.
25.
Yes. Please state why, after tabular column, last column, the
Ah,
amount.
Agreed, my lord. My lord, there is a difference in the
You
consideration.
have to show the source of income. That is one.
That I have shown, my lord. His grievance is that you have, where is your source?
Page 74, he says it has not been explained.
Yes.
The
So,
assessee has filed
Kindly
a deed of conveyance.
kindly see my reply, my lord.
No,
My reply at page 28.
see, no explanation regarding source of funds of purchasing property has been filed. Payments of purchase consideration has been made through demand draft drawn on State Bank of India, assessee maintaining bank account with Allahabad Bank, and its statement for the period has been filed. Assessee has failed to furnish detail of source of funds with supporting evidence. You do that in the 148.
My lord, that I have done, my lord. Kindly see my reply once.
We have seen the reply.
Page 28, my lord.
Yes, it is
All
there.
these deeds are before the AO, my lord.
Sorry, sir.
My lord, kindly, my lord, very small, kindly see his
A very
computation.
small assessee
But
only.
50,000 he made money out of that. And he is having, kindly see the computation of income. Otherwise, he would not have engaged a small lawyer like me. He would have gone to some big lawyer.
Said Mr. Subhas Agarwal.
Person
says
earning
small.
10,000 rupees according to my lord.
You know,
Not even.
kindly see page 71. my
Probably
lord.
this is the tip of the iceberg.
You know, page 71, he is caught on the wrong foot. But still, my lord, law of limitation is saving me. It is the actual,
You have got an excellent case in 148. You place all the documents, you get.
my
This
lord,
merits of the matter.
you kindly see, my lord, page 71, my lord. 84,000 is my salary, 50,000 I earned from capital gains.
Because these are part-time accountants, they are all paid in cash.
How much, my lord? At 1,50,000, that may be the escaped income. He just dreamed a little bit big that I will purchase a property, I will make a profit. Some friends promised him that I will finance you. So he was working with a builder. So that money could not be arranged, so he had to sell the property.
We'll direct the AO to consider all those aspects. More particularly, he is an individual assessee and impugn notice was, that is, where have you in your grounds, where have you stated that you are below the
Yes.
tax bracket, you need not file return.
My lord, in my reply, I have submitted para 1.
Please come. This intra-court appeal by the writ petitioner is directed against the order dated.
My lord, ground is also at page 109, ground number 18.
Yes. Order dated 8th June 2023 in WPO 1120/2023. The appellant had filed the writ petition challenging an order passed by the respondent assessing officer under section 148 capital A within bracket D of the small d of the Income Tax Act 1961 within bracket the Act dated 31st March 2023 for the assessment year 2016. The writ petition has been dismissed by the learned single bench on the ground that the assessee has ample opportunity to put forth all their contentions in the reopening proceedings pursuant to the notice issued under section 148 of the Act. As could be seen from the relevant documents filed in the stay petition, a notice dated 14/3/2023 was issued under section 148 capital A within bracket small b of the Act, wherein a purchase of an immovable property affected by the assessee was subject matter of issue. The assessee was furnished a questionnaire containing 7 questions. The assessee submitted their reply dated 21st March 2023, stating that the income tax return was not filed by him because the assessee's total income is below the threshold limit. Certain explanation was
Milord, one
also given.
alternate ground I forgot to mention, Milord. The notice has been issued by jurisdictional AO. Now under 151A, after 29th March 2022, it is to be issued by the faceless authority. So jurisdictional AO no more is vested with the jurisdiction, Milord.
That ground was raised?
That ground was raised. There is a Rajasthan High Court on that, and
No, where
various
is
other
that
high
ground?
courts are also granting stay, Milord.
Where is the ground?
Milord.
It is not there.
Milord, page 107, ground number 10. Page 107, ground number 10.
And
Beyond threshold limit and certain explanation was.
and a certain explanation was given with regard to the purchase of the property, immovable property. The assessing officer, upon consideration of the explanation, has passed an order dated 31/3/2023 under section 148 capital A in bracket small d of the Act. On perusal of the order, it is seen that the assessing officer has examined the merits of the matter and has come to a conclusion that the assessee has failed to furnish details of source of funds with supporting evidence, and the submissions of the assessee is not found tenable. This order was put to challenge in the writ petition. The assessee contended that the notice under section 148 has been issued on March 31, 2023, beyond the period of 3 years from the end of the relevant assessment year. Therefore, it's not sustainable in law, being barred by limitation, in as much as the alleged / likely escape of income is there less than rupees 50 lakhs. The assessee has also questioned the jurisdiction of the assessing officer, stating that it is only the faceless assessment authority who can proceed with the matter. The issue which was subject matter of the show cause notice.
Milord, may I submit the decision of Rajasthan High Court where
Not
stay?
required, sir. Don't foreclose the matter. The subject matter of the show cause notice issued under section 148 capital A within bracket small b of the Act is concerning the purchase of an immovable property and the valuation of the property as well. Apart from that, there was an allegation that the assessee has not filed his income tax return. Assessee was called upon to furnish the requisite documents to support their contention. The assessee has furnished a copy of the deed of conveyance and has stated that the assessee's total income is below the threshold limit and he is not required to file an income tax return. These aspects of the matter are to be examined by the assessing officer, which will require adjudication into factual aspects, much of which has been disputed by the assessee. With regard to the jurisdiction of the assessing officer to issue the notice, such a point was canvassed for the first time before in the writ petition. If in the opinion of the assessee, the show cause notice itself was barred by limitation or was bad for any other reason, this issue ought to have been raised by the assessee at the first instance. However, we do not wish to foreclose the assessee from canvassing these points in the reopening proceedings, which will be conducted by the assessing officer pursuant to the notice issued under section 148 of the Act dated 31/3/2023. For the above reasons, we are of the view that the learned single bench was right in not interfering with the order passed by the assessing officer under section 148 capital A within bracket small d of the Act. The result, the appeal is dismissed, leaving it open to the assessee to raise, canvass all points in the reopening, in the reassessment proceedings, including the issues relating to the jurisdiction and as to the requirement of the assessee to file an income tax return for the assessment year under consideration. Appeal dismissed with above observations. Next.
Grateful, my lord.
Oh God. He's waiting. Which is that item number? Item 10. 12. 10. We'll start there. There's a
Specially fixed matter, item number 10.
We'll take up there.
But this won't take much long because we are only filing paper books today.
Which one, sir?
Item 6.
Item 6. Oh. All right.
And your lordship may post this matter on 21st, subject to lordship's kind convenience.
Anjan, on what day election matter is starting? Then, all right. Item 6, you please take one. The learned advocate appearing for the respondent assessee has filed a paper book, copy of which has been served on the learned advocate for the appellant. Let the appeal appear in the admission list on 21st. Great.
Lord, may I pray for taking up the item number 7 only? It will take only 1 minute time.
Yes. 7, what is the modification?
My lord, modification, my lord has passed an order allowing my appeal. Then the assistant registrar, High Court, give me a letter. Background of this case is that initially while interim order was passed, this court has directed me to deposit 7.5 lakhs.
Yes.
I deposit before the registrar. So after allowing my appeal, my lord, when I allowed my appeal, I paid for that money.
To be
then this assistant registrar is writing me later that it is a specific order of the court is required. It is at page 23.
Correct.
This is the case.
This application has been filed. Item 7, please take down, sir. IA number GA2 of 2023. This application has been filed by the assessee for a direction upon the learned registrar original side of this court to release the amount of 7,50,000 deposited in compliance of the interim order passed in this appeal, in the appeal on 8/4/2009. By judgment dated 3rd May 2023, the main appeal in Section 1 of 2009 was dismissed. No, allowed. Consequently, the whatever deposit which was made by the applicant/appellant pursuant to interim orders granted by this court has to be refunded to the appellant. applicant slash appellant. Accordingly, there will be a direction to the learned registrar, original side of this court, to refund the amount which is lying in deposit, which was made by the appellant pursuant to the interim orders passed by this court on 8/4/2009.
Yes.
With the above direction, application is disposed of.
Below the item 8.
What is 8?
My lord, along with interest,
Along with
accrued interest.
accrued interest, if any.
Yes, yes. Yes, when it is in the bank, it will, along with accrued interest, if any, already.
If any.
Yes, yes.
Then what is
Milord,
item 8?
Item 8, my lord, there is a review petition. Milord, section 5 may be considered by.
294 days delay, we have filed a opposition, my lord, to the main, as per lordship direction, my lord, to the main matter, and also to the section 5 application, we have filed opposition, my lord.
My lord, it was
294 days.
Sir, item 8, please take down. We have heard Mr. Subhash Agarwal and
mainly there was delay due to approaching Supreme Court.
and Mr. Prithvi Dorial and senior standing counsel for the respondent. There is a delay of dash days in filing the review application.
294.
We have heard the submission of the learned advocate for the applicant as well as the learned standing counsel, and also considered the affidavit in opposition filed by the revenue. The delay has been properly explained. And it is seen that the appellant had earlier approached the Honorable Supreme Court, and thereafter this review application has been filed after withdrawal of the special leave petition. Therefore, the delay in filing the review application is condoned. Let the review application be listed for admission on so and so.
Lord, we have filed a opposition pursuant to lordship direction, my lord, regarding delay and main matter also. Two affidavits have been filed, my lord. Lordship kindly keep.
And the revenue has also filed an affidavit in opposition to the grounds canvassed in the review application.
As well as section 5.
That we have recorded,
Yeah.
which is taken on record.
Yes.
Next.
Lord, a reply I am dispensing with. I am not replying. Deeply.
Grateful, Lord.
What is item 9?
Lord, I am for the item there.
No, I'm at the state now.
Lord, the state is today is absent. No, not today, my lord, not today.
Let it remain in the list.
Yes, yes. Lord, item number 28, 29 of the monthly list.
No, item number 9, not today.
No, no, no. 28 and 29 monthly list, what are 3 weeks time will required, my lord. So the leading council will out of station, my lord. 28 and 29, not 3 weeks.
28, 29.
3 weeks adjournment, my lord.
Monthly list.
28, 29.
No, why can't it remain in the list?
Yes, 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 yes.
If you disturb that list,
No,
then
yes, 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 yes.
let it remain. On that date, when it's taken up, if he is not available, we'll adjourn.
Item number 10.
We have concluded, my lord.
Yes. Sir.
My lord, I appeal for the respondent, may it please the lordship.
Yes.
My lord, the facts of the case are more or less, my lord, placed before the lordship. My lord, so far as the grievances are concerned, my lord, I will touch and address so far the facts are concerned only to the extent, my lord, which they have placed and addressed to your lordship, and to the extent which are relevant for my lords to adjudicate and decide this appeal. Now, my lord, in a nutshell, my lord, there are 4 or 5 points, my lord, which the appellants have placed before your lordship. My lord, firstly, so far as with regard to Subhash Popole judgment, as reported in 2014, volume 4, SCC 657.
Yes.
It is the contention of the appellant that the proceedings under 1971 Act will not be applicable so far as the appellants are concerned. Now, so far as my lord, this aspect is concerned, there has been an alternative submissions also in as much as I have understood, subject to my lord's kind pleasure, that even if the PP Act is applicable, my lord, the respondent LICI, my lord, cannot act arbitrarily and with unreasonableness so far as the revision of rent is concerned. And my lord, the authority being framed under Article 12 of the Constitution of India, my lord, has to, my lord, make a distinction between, my lord, that with the private landlords are concerned. And so according to them, my lord, it offends and violates Article 14 of the Constitution of India. Now, so far as, my lord, second point is concerned, they say, my lord, that we are a bona fide tenant. And, my lord, according to them, since their right confers with regard to the bona fideness, as they perceive, my lord, that we would like to, my lord, enhance and follow the agreement, the so-called purported agreement of the 1991 is concerned, we would like to enhance the 35% rent, which we did not agree. And according to them, it is their understanding that we are bona fide tenant. So for the third point is concerned, my lord, that according to them, my lord, there are certain guidelines of 1992 is concerned, which my learned senior adversary has placed before lordship. And with regard to that guidelines, my lord, it is on their contentions that these guidelines, my lord, are binding on us. And even if, my lord, an alternative proposition has also placed that even if, my lord, it doesn't have any statutory flavor, but since, my lord, these are an administrative instructions. So, my lord, we being the LIC, being a, my lord, a creature of the Article 12, we have to follow and we cannot ignore this. There are certain other submissions, my lord, that the act being a draconian act, and, my lord, the estate officer being an officer of a, my lord, respondent, should not be, my lord, given certain, my lord, indulgence that he might not have, my lord, so far as his actions are concerned. It may be, my lord, something prejudicial to the tenants, as being, my lord, he is an officer of the state. I'm sorry, my lord, officer of the LICI being the estate officer. And also, my lord, there another point is that so far as the notice under section 4.1 is concerned, that there are no reasons, or the reasons which are there, my lord, reasons are not sufficient. It is according to the appellants, my lord, this has to be in terms of the rule 3 and, my lord, form A is concerned. Now, on these aspects, my lord, I will try to address your lordship, my lord, some facts, as I indicated, my lord, which may be relevant for my lords to decide and adjudicate.
Yes.
My lord, kindly comes to my lord, see, my lord, some grounds, my lord, which they have placed before lordship.
In the memo of appeal.
Memo of appeal. My lord, let us first take, my lord, ground number 3. Well, I would place the ground first, thereafter I will try to, my lord, on these aspects of the submissions which they have made, and I would only try to indicate the grounds which in relation to this, to the arguments are concerned.
Ground 3.
Ground 3. The ought to have the considered and are in failing to consider that the initiation and continuation of the proceedings without there being any breach of the existing contract of tenancy on the part of the petitioner, and on the ground that the petitioner number 1 had not agreed to the execution of the lease, being unwilling in a most reasonable revision of rent, are in violation of the central government order 1992 and 2002, which are binding on LICI in view of section 62C, read with section 21 of the LICI Act 1956, which in view. Now, my lord, it has two facets. One is with regard to that there was no breach of the existing contract. Now, my lord, whether there was a breach or not, it is purely a question, my lord, a disputed question of facts. And according to them, my lord, that there is no breach because of the thing. Why? Because they are willing to proceed in terms of 1991. So for the other facets is concerned, that there are a guideline which according to them, my lord, is binding and I am not following. Now, my lord, I recall 2002 guideline. Now, my lord, so far as 1992 guidelines are concerned, my lord has already gone into. I need not require to trouble your lordship. That guideline, my lord, will find, my lord, in the application at page 121. Now, my lord, there was a 2002 guideline which was also noted and considered by the learned judge, but it was not referred to your lordship. Neither I have found that it is annexed to the appeal.
Is a supplementary on.
Yes. No, supplement, of course. It is not a part of the writ petition. They have produced it by way of a supplementary affidavit. Maybe it is a my mistake, but I do not find in none of the 7 volumes, the supplementary affidavit has been made a part of the appeal with regard to the application. Now, this is a supplementary affidavit. Kindly turns to Miller. First, this is it's not a legible copy. The second part is a first one is a illegible. The second part is a legible copy. Kindly turn to the relevant portion. The question of notification of the guideline to prevent arbitrary use to evict genuine tenants of the public premises, such and such. To prevent arbitrary use of the powers to evict genuine tenants from the PP Act and to limit to the use of the powers, Estate Officer under Section 3, it has been decided by the government to lay down the following guidelines. The provisions of the PP Act should be used primarily to evict totally unauthorized occupants of the premises of the public authorities of sublet or employees who have been ceased to be in their service and thus ineligible for occupation of the premises. The PP Act, the provisions of the PP Act should not be used, should not be resorted to either with a commercial motive or to secure vacant possession of the premises in order to accommodate their own employees, where the premises were in occupation of the original tenants to whom the premises were let either by the public authorities or the persons to whom the premises were acquired. A person in occupation of any premises should not be treated or declared as an unauthorized occupant merely on service or notice of termination, but the fact of unauthorized occupation shall be decided by following the due procedure of law. But it inherent says that due procedure of law. Now, it is not the case, so far as the intra-virus is concerned, the applicability of 1971 Act with regard to the public premises, it is not none of the case. It is not a public premises. It does not fall within the definition of public premises. It is also not that I being an authority of a state, so far as this premises is concerned, I cannot act with regard to this particular premises, which is considered to be a public premises concern. Further, the contractual agreement shall not be wound up by taking advantage of the provisions of 1971 Act. At the same time, it will be open to the public authority to secure periodic revision of rent in terms of the provisions of the Rent Control Act in each state, or to move under the there are certain under the genuine tenants under the Rent Control Act for resuming possession. In other words, the public authority would have the right similar to the private landlord under the Rent Control Act in dealing with the genuine legal tenants. Now, again, we come up here, whether he is a genuine or bona fide tenant or not, it is entirely for the estate officer to decide. He is not otherwise out of scope of placing his grievance. That estate officer cannot be or he is not being permitted or legally authorized to deal with all the issues. The 1971 Act is a complete code, is time and again, starting from Hori Singh onwards. I will show also some a constitutional bench judgment even passed prior to Ashoka Marketing, which also held and decided that this the intra-virus of the 1971 Act is concerned. It is necessary to give no room for allegations that the evictions were selectively resorted for the purpose of securing an unwarranted increase in rent, or that a change of tenancy was permitted in order to benefit particular individuals or institutions. In order to avoid such imputations or abuse of discretionary power, the release of premises or change of tenancy should be decided at the level of Board of Directors of the public undertaking. All these public undertakings should immediately review all pending cases such and such under the against the genuine tenants on the ground otherwise than as provided in this guideline. The PP Acts should be used henceforth only in accordance with these guidelines. Now, Millard, this notification is 2002 has come up, Millard, in subsequent in modifications of 1992 guidelines, which my lords would place on record in my lord's brief at volume 1, page 121. My lords may, for the time being, also have a look to that 1992 notification.
Yes.
ওইটা একবার দেখি তো, আমার যে তুমি যে কপিটা এনেছো সেটা একবার দাও, প্রথম যেটা দেখা যায় ওইটা। Now, my lord, kindly turns to page 122. My lord, fourth line from the top. In order to prevent arbitrary use, my lord has found, my lord, of the provisions of the PP Act to evict genuine tenants and to limit the use of the summary powers primarily to evict unauthorized occupants and retired such and such. This will ensure companies with the split underlying the protection extended by the parliament to those premises and the observation of the Supreme Court while upholding the validity of the amended act. The guidelines given below set limits for the resort to the PP Act by the PSCs and are to ensure for the interests of the genuine tenants are not jeopardized. The following are the guidelines. The provisions of the PP Act should be used primarily to evict totally illegal occupants. So, my lord, according to me, is for me, my lord, I am the landlord. I am to find and, my lord, assess, my lord, who is legal and who is not legal. And, my lord, so far as his occupation is concerned, if your lordship, I will take your lordship, my lord, also to the trouble that the definitions of, my lord, the unauthorized occupation. And, my lord, when from the date, my lord, I determined his tenancy.
He becomes illegal.
Illegal. And, my lord, the application of Subhash Popole will be, my lord, it's not at all applicable because it is not, my lord, to be decided when he was, my lord, brought into the premises. The deciding factor would be that the date when he has become unauthorized. Because he cannot take, my lord, all the way around that since, my lord, he came in the premises prior to the cutoff date. So all through the years together, my lord, no proceedings can be initiated. I would submit, my lord, and there are certain judgments which I place with lordship. It is on the basis of the, my lord, issue that when his possession has been declared unauthorized. After the premises become the public premises. Now, the provisions of the Act should not be resorted to either with a commercial motive or to secure vacant possession of the premises in order to accommodate their own employees where such and such original tenants.
That will not apply.
3, a person in occupation of any premises should not be treated or declared to be an unauthorized occupant merely on the service of notice of tenancy or should any termination of tenancy or should any contractual agreement be wound up by taking advantage of the provision of the Act. At the same time, it will be open to the public authority to secure periodic revision of rent in terms of the Rent Control Act in each state or to move such and such. To resuming possession, in other words, the public authority would have rights similar to the private landlord such and such. It is necessary to give room for allegations that evictees were selectively resorted to the purpose of unordered increase in rent or that change in tenancy was permitted in order to benefit particular individuals such and such in order to avoid such and such. Now, the occupation was commercial. Occupation was commercial. He was running a business that is not undisputed. It is also not disputed, my lord, that when he had been in possession of the property, sometimes possibly in 54, 55 or 56. And it is also not in disputed, my lord, that there was a contractual relationship between my lord, because he has also accepted me as a landlord. So he is stopped, my lord, in denying my right over the property in terms of the Evidence Act. And there was a contract relationship up to the date of termination, or when I decided, my lord, that his occupation become illegal. Now, 1994 supplementary 3. My lord, on so far as my lord, I would rely first, my lord, the judgment of the Honorable Supreme Court reported in 1994 supplementary 3 Supreme Court cases, page 694, in a case reported between Jivan Das and Life Insurance Corporation of India and another. No? ওইটা আমার কাছে আছে। My lord, kindly, it's a very short judgment. Paragraph 3 and paragraph 4. My lord, it deals with the propositions of whether the LIC or my lord, any my lord, under the Public Premises Act, any authority, my lord, can seek for revision, unlike my lord, private landlords. Kindly comes to my lord, the facts of this case also. Here, my lord, the appellant also was inducted in 1949. The first sentence. Kindly mark this, my lord, 1949,
Yes.
as a tenant on the ground. Here, my lord, they say that I was there prior to, my lord, the cutoff date. Now, my lord, notice under section 106 of the TP Act was issued for for initiating the proceeding under section PP Act. Then appellant filed a writ petition in the Delhi High Court. The division bench summarily dismissed. Thereafter, appeal. See, such and such, the learned senior counsel of the appellant content the respondent corporation being a public authority before initiating the action under section 5 is enjoined to assign reasons. Here, my lord, I would also couple that he said there is no reason. So it covers, my lord, 3 limbs. Whether, my lord, I can increase, or whether, my lord, is a periodical increase, I have a right to increase, or whether his actions are bona fide concern. It also deals with that whether, my lord, is a lack of reasons. Because I would show from the act, my lord, it says any reasons. It doesn't restrict or limit, my lord, so far the ambit of the act is concerned. Is enjoined to assign any reasons which must be just and germane for the purpose to exercise its reasonableness must be tested on the touchstone of Article 14. He further contends that unless the public authority justifies the action under section 5(1) of the Act before determining the tenancy under 106, under section 106, it is violative of Article 14 of the Constitution. We find no force in the contention. Sorry. This court in Hori Singh, by a bench of 7 judges, upheld the constitutional validity and retrospectively. Mellor may recall, Mellor, I have referred to Hori Singh and I have brought this judgment. The scheme of the 1971 Act is that it confers power on the estate officer to issue notice to persons Hori Singh Barkar, who are in unlawful occupation of any public premises to show cause why an order of eviction should not be made. Unauthorized occupation, quote unquote, under the Act in relation to any public premises means the occupation by any person of the public premises without the authority for such occupation, and includes the continuance in occupation by any person of the public premises after the authority, within bracket, whether by way of grant of any other mode of transfer, bracket close, under which he was allowed to occupy the premises has expired or has been determined for any reason whatsoever. Now, pausing here for a moment, kindly takes up Public Premises Tenancy Act. Public Premises Tenancy Act 1971. But this Hori Singh, I will now produce, pausing here for a moment, Lordship, kindly also side by side read the Hori Singh. The issue of the Hori Singh, whether the act was intra-virus or not, whether it's a complete court. Here, my lord, there's a prior to 1971 Act is concerned. There was a 2 mode of a process of adjudications. One may be some leniency, one may be very extraordinary or with some draconian steps. Here, in 1971 Act, section 15 prescribes only 1 mode of adjudications, where expressly barred any other forum to adjudicate so far the proceedings, if any, under 1971 Act, and that was addressed, adjudicated, and held to be valid in law in the Hari Singh 7 judges constitution bench. So far the other point is concerned, it says that if I take any other recourse other than by public premises, that would offend Article 14. Then there would be, my lord, a treating, my lord, two equals, my lord, with the unequality. Because here, my lord, the Act provides me only to proceed under Section 15. Now, my lord, kindly turns to Section 15 of the Act, the bar of jurisdiction. This point, my lord, was not addressed by them. It is my duty to point out to your lordship, my lord. And I would also show, my lord, Subhash Popole I will distinguish, and Subhash Popole also, there are other judgments, and also these particular things. So for the Hari Singh is concerned, I'm extremely sorry, my lord, Justice Bhattacharya, my lord. Please permit me. Kindly turns to, my lord, Section 15, the bar of jurisdiction. No court, it starts with a non-obstante clause. And unless it produces and show, my lord, the prima facie that there are other acts which also come up with a non-obstante clause, my lord, so far as the applicability of this act, my lord, cannot be called into question so far as the ambit of Section 15. No court shall have jurisdiction to entertain any suit or proceeding in respect of A, the eviction of any person who is in unauthorized occupation, which is a subject matter before the estate officer. B, the removal of, this is not an issue. The C, demolition of the issue. Then the sealing of any erection, this is not issue. Then D is important. The arrears of rent payable under subsection 1 of section 7 and damages payable under subsection 2 or interest payable under subsection 2A of that particular section. And there are etc. such and such. So, my lord, this is a non-obstante clause, makes it more imperative and is a binding nature on me that if I go or take something recourse in a different, it would offend Article 14. Because I being a state, my lord, I do not follow this. Whereas, my lord, Hari Singh says that there is only one mode prescribed under the Act. And that is why 1971 Act was said to be intra vires. And Hari Singh also considered that why the earlier Act, there was a shortcoming that there are two modes of, my lord, adjudication. By 1971 Act, that has been cured. Now, kindly takes up, my lord, before taking into Hari Singh, kindly see, my lord, that what are the adjudications for. Kindly turns to, my lord, volume 3. Page 378. I'm sorry, my lord.
How much time you will require, sir? Another 1 hour session. Because second half, it's actually appellate side. You're just thinking whether we can.
May I only, my lord, already we are on recess. I would only request your lordship, my lord, today, if my lord's permit, subject to my lord's business permits, my lord, to place this Jivan Das and Hari Singh. So far as the other parts is concerned, my lords, according to my lord's suitability, my lords may permit me. Or else, my lord, it may be, my lord, or my lord, shortcomings for me that I again start with Jivan Das and Hari Singh, if subject to my lord's pleasure.
Suppose we continue this up to 3:30.
I'm sorry to putting your lordship into inconvenience, my lord.
So any specially fixed matter is there, appellate side?
Well, I would come back on the next day. I'm sorry to trouble your
No,
lordship.
No, you.
Amaro আছে।
Okay, then no problem.
আমারই আছে তো। But so far as my lord's query that there is a specially fixed matter, I would have been privileged to address one of the special fixed matter.
That is your matter also.
Yes, yes.
You please, we'll continue. You can continue in the afternoon, 2:30, you please come.
My lord.
This matter we will continue. This LIC matter, we'll take it up.
My lord, kindly take it up on any other day, my lord, because otherwise the appellate side list will be disturbed. And I have a matter fixed and appellate side is specially fixed.
If it was.
My lord, for keeping interest of one client, my lord, the other client's interest, my lord, also, my lord, subject to place.
All right, we have heard Mr. Basu, learned advocate appearing for the respondent LIC. For continuation of arguments, list on soon. What date? Next Friday will be what date? Is this Friday? All right, on Friday.
Friday.
Day after tomorrow, Friday. But any time, not at all. My lord, any time.
Second half.
Second half.
Second half.
I'm sorry for my lord's to
No.
hold.
Yes,
With your lordship's leave, may I mention a matter, your lordship? Pursuant to your lordship's direction, I am mentioning this matter being MAT number 1518 of 2023. It was filed by us yesterday. Now, the state has already filed an appeal being MAT number 1148 of 2023, which is due to appear as item number 10 in today's list. Would it be your lordship's pleasure to take both the matters in concurrence, your lordship?
that is 1148 is this state's appeal.
State's appeal, your lordship.
Where is your appeal?
1158, we have filed it yesterday. It's lying in the filing section, the record, your lordship.
And who will appear, advocate?
I'm in item number 10, but I'm not very sure whether we've been served. At least I don't know. I'm in item number 10 for the state.
I'm the writ petitioner. I've been served.
Okay. Service officer, GP officer. Oh.
Service is not yet complete, your lordship, but would you?
Then we'll take it up tomorrow.
But tomorrow I'm in some difficulty. Next week there is no difficulty, or today your lordships may take it up.
Tomorrow 2 p.m. my lord, if it suits.
No, tomorrow 2 p.m. there's another DB. You
Then
serve
let it be
paper-
taken up today, your lordship. Let the matter 1148.
No, your appeal is not on file.
This is the Kharagpur IIT matter which my lords had taken up last week.
And who are you? You are the IIT.
I am for the IIT, your lordship. We have also filed the first
You
miscellaneous.
serve copies on the state government. He is supporting your case.
Grateful.
Grateful.
Lord, kindly take it up on Wednesday in that case, Lord, so that I may be aware of what is the appeal and get myself ready.
Item 10, list along with my MAT number so and so.
Let it remain in its
Yes,
position.
Yes.
Otherwise, item
in
1000.
in the admission list, higher on board. Yes, please call the list.
Grateful.
Appellate side, daily list, serial number 1.
And one submission, my lord, I make. But on the last occasion, there was another appeal. My lords were looking for the amicus curiae appointed by the learned judge, single judge. But I have given notice to the learned amicus curiae, my lord. I
have been served with a notice given by him.
Although the appellants had not served the amicus, my lord, I have.
Then you can appear next Wednesday. Yes. Yes, item 1.
In item 1, my lord, the respondent number, I am appearing for the respondent number 1 and led by Mr. Shomo Mojumdar, my lord. He is not present for his personal difficulty, my lord.
No problem. Last time Advocate General was not there.
This is my appeal.
We were asking you, sir, now what survives in this matter?
Contractual period is already over.
Contract is over, but his allegation is that you are still continuing.
No.
No. He is the
contractual period is also not over. Lord, if your lordship is pleased to take Lord page 18 of your lordship's brief.
It is for 2 years.
No, my lord, please see, my lord. It is for 2 years with effect from the date of signing of agreement or contract.
Yes.
So the agreement was signed
on what date?
8th of
December
2021. 8th of December 2021. But Lord, after being interjected by the order of the Honorable Single Bench, which
December.
is 22nd of 5th of January 2021, thereafter, Lord, the contract has not been performed.
No, from
No, the
agreement was signed on 8th December 2020.
8th December
8th December 2021 is the agreement. The agreement was interjected on 5th of January 2021.
2022.
5th of January 2021 is the judgment of the single bench.
8 December
5th of January.
2020 was
8th of December 2020. I'm sorry, 8th of December 2020. 2020.
So within hardly a month, the order of injunction was granted or writ was allowed?
No, writ was allowed.
And after that, what has happened?
I'm not after that, Lord, which we've put on record, and it's part of an order that we've directed not supply to be made by the earlier contractor. That was placed before the Honorable Division Bench. That
doesn't matter. From when he is supplying from 5th of January or immediately thereafter?
Yes,
till
Lord.
date he is supplying.
Yes, Lord.
Then you do one thing, you call for fresh tenders.
Yes,
Lord, so far as we are concerned, Lord, we do not have any difficulty. But Lord, so far as this particular tender is concerned, this tender's period is from the date of signing of the agreement, not from the date of the tender papers being issued or from the date of the date of the NIT. So the successful tenderer has had a period of only 1 month, but he has deposited security deposit for the entire period of 2 years.
And there was a clause for 1 year extension also.
All right.
May I just, please?
My lord, may I just place my case, my lord? This is the date of signing of the tender document was 8 December, agreement was 8 December 2020, my lord. And from that period to 7 December 2022, 2 years is completed. So contractual period is already 2 years is over. And so far the concerned about the extension period of 6 months thereafter, my lord, which is appearing from the page 18 of the tender document. And that is also about to be over, my lord, because we are in the month of August. And my lord, the fresh contractual period can be initiated. The allegation, the contention of the writ petition is made.
My lord, it is my appeal, my lord, let me place, my lord, he is going into the merit. My lord, let me place, my lord, this was a tender of ESI. My lord, kindly take, my lord, page 18, it's the tender notice, it starts from.
No, instead of that,
Yes.
you please tell on what ground the award of the tender
Yes,
was challenged.
there was.
Why don't you
I'll
paraphrase it?
in
Otherwise, you're running against time.
in technical bids, after technical bids, 5 bidders were selected, and there are checklists, which says that all the 5 bidders have given all the documents. Then there was a provisions for lottery because all 5 bidders quoted the same rate. But in the meantime, a letter came from the hospital authority. I don't know why. Out of 10 participating bidders, 9 were issued a notice that you should file these documents. But that was not the checklist, not as per the checklist, because checklist says all the 5 successful bidders filed all documents required. I also one of them. Then the lottery was conducted. He didn't participate. In the lottery, I was selected. I was given the work order. Now, in the writ petition, he claimed that the letter given to the 9 tenderers, out of whom 4 have been rejected at the technical stage, he claimed that this document was lacking. So the selections of other 5 bidders were illegal. And since it's the retender, I remained to be the sole bidder, I should be given the contract. And that was the basis. He did not disclose 2-3 documents that I want to show. And I was selected by the 8th of December, agreement was entered into without making me party respondent. He filed the writ petitions and it was taken as expertise. And the learned judge kindly take observation of the learned single judge. It starts from page 71. Kindly take page 71 once, and paragraph. The relevant part is paragraph page.
Where does the discussion start?
Page 83,
Discussion starts, case of the writ petition starts from.
Please sit down. Please sit down. Please take your seat.
Once, you will kindly take page 83, once, paragraph 30. I'll come to the discussions of the learned single judge. Although the bidders in whose favor the work order have been issued, if any, pursuant to the impugned memorandum, have not been implemented in the present writ petition, since such persons are the beneficiaries of the illegal actions of the respondents, in view of the respondents having proceeded with the tender process despite having notice of the writ petition, the said persons are not parties to the writ petition and their non-implement does not hinder the disposal of the writ petition.
And you filed this appeal after obtaining.
After this, because immediately with the leave of the court, immediately I filed. But by that time, they gave the work on ad hoc basis to the earlier contractor.
That is subject to the
yes, that was the interim order passed by the division bench. And kindly take 2 documents, page. Kindly take page 37 first, my lord. It's in folded form.
annexure P2. These are the checklists. But you also will find the first page, the top is the documents required, the 37, and mine will come page, next page, serial number 11. Okay. Yes.
Annexure P2, is it?
Yes, annexure P2, that is the checklist. Kindly take serial number 11, page 38. Has your lordship got it?
No, it is 38 in my set.
Oh, it starts from, in my brief, it starts from
Doesn't matter.
37. 38,
And page 39.
Yes, then, I'm sorry, my lord.
No problem.
Yes.
The checklist starts.
Yes, checklist. Then, serial number 11, you will also find my client, Jana Enterprise, and you will also find that all the documents have been furnished. Those are the tick marks given.
Very good.
And the next page, kindly take page 39.
17.
Yes, last paragraph, remarks. Whereas it also noted the bid serial number, United Order, that the petitioner, the Jana Enterprise, Prantha Supply, Rupa Enterprise have submitted all prerequisite necessary documents pertaining to the technical bid and are considered as technically valid pertaining to the e-tender of the supply of cooked diet, such and such. Then, my lord, this was the technical bid stage, not at the stage of financial bid. And this, it was uploaded, page 41, it was uploaded. Then kindly take, page 44. These are the successful bidder, and after the open page 44, all were L1 because the rates were quoted. These are the 5 bidders, out of total 10 bidders. 44, my lord. It should be 45 in your lordship's brief.
Yes. United Order, Jana.
Yes.
Tinka, yes.
Now this, my lord, I don't know why this notice was issued. This was most probably intended to favor someone. Kindly take page 45. That was the basis of their writ petitions. Page 45. Your lordship's brief is for page 46, most probably, my lord. It is dated 10th of November 2010. And you also will find all 16 bidders, my lord, out of which, my lord, most of them rejected. They were issued notice that kindly.
Actually, they should have, if additional documents were required, according to you, they should have called for only from 5.
Only from 5. And all have been, my lord, this is the basis of their writ petitions. Now kindly take, my lord, what happened, page 47. Now 48 it should be. This was, you also will find the financial bid opened in presence of all members. Now this is retender. My lord, what was retender? Because the earlier tender, my lord, after that, my lord, that schedule changed, price changed. So earlier, which was the tender, that was withdrawn. Now this is not a tender under second call. My lord, there is a circular of the government of West Bengal that if it is a second call tender, my lord, if there is no 3 bidders or sufficient bidders, my lord, even the single bidder can be, my lord, awarded with the approval of the government. Now they tried to take advantage of the circular, saying that, see, this notice was issued to all concerned, not to me, because only his name was, my lord, absent in the notice.
In which notice?
In the 46 notice, my lord. 10th November notice. My lord, it should be in your lordship. 46. You also will not find this, only the petitioner name is absent.
No, it is GS Enterprise.
No, my lord, shortfall documents notice, my lord, just I had shown, my lord, page 40.
Yes.
46, lordships.
46. 46.
Now you also will not find only his, my lord, the writ petitioner name is not mentioned.
Yes.
And that is the advantage he shot for, my lord, before the
Saying that he is fully satisfied.
He has fully, so only one bidder. So as per the circular of the.
Then what is the explanation for page 45 or 44?
Yes, that is the successful bidders technically qualified. Well, this notice could not have come.
It could have come if
only limited to 5 bidders.
May I take it, your lordship?
Yes.
আমাকে একটু বলতে দিও, হ্যাঁ, disturb নাই। স্যার, আমি একটু শেষ করে নিই। show করবো। Now then, my lord, I was awarded, kindly take, my lord, page 49. Page 49. This was the letter of acceptance given by the hospital authority after, my lord, lottery. Your lordship brief, page
Oh,
40.
GS Enterprise.
Yes,
That lottery, 5 people participated.
5 people participated and I got selected. আমারটা GS Enterprise.
No, your client is GS Enterprise.
No, I'm sorry, my lord, appellant is GS Enterprise.
You said Jana.
No, no, sorry, my lord.
Dilip Jana is that appellant.
Yes, yes. No, no,
Proprietor.
GS Enterprise.
He's proprietor.
Ah,
Okay.
same thing, same thing. I'm the proprietor of the GS Enterprise. I'm
Okay,
sorry,
very
my lord.
good. So they gave you an acceptance
And
letter.
on 7th December, then security deposit furnished on 8th December.
Contract entered.
Contract and this tender was, this writ petition was filed, my lord, on 14th of December 2020. My lord, by that time I had started working. 14th of December.
And according to him, he is taking to take advantage of the communication
Yes.
dated 10/11/2020,
Yes.
saying that his name was not there in the short form.
So he was the only successful bidder and he's short to rely on. My lord, kindly take page 85. This is the circular of the government of West Bengal.
Single bidder should not be accepted.
It cannot be, but if it is second call or subsequent call, then it can be accepted. My lord, generally, my lord, when the second call comes, my lord, when there are no initially 3 bidders.
Page number?
Page 85, my lord. But your lordship brief 86 most probably.
There are only 84 pages.
My lord, your lordship, it's a
Yes, sir.
vacating application, so the state, my lord, there is leave to appeal, my lord. I'm sorry, my lord, I have number 1.
Oh,
Or
that's it.
referring stay applications, my lord. There are
And
2
number two.
applications. my lord.
86.
Yes, yes.
And number 2 can you
I'm sorry, my lord.
No problem. sir.
Because leave was disposed of, I was referring.
If the number of qualified in one day, in which clause you want to rely?
My lord, kindly take in respect of the tender, it is less than 3, then tender is invited in afresh, first paragraph in of note 1 below rule 37 such and such as the tender notice or written, if any, is required to be published prior to invitations of the tendering authority. However, in case of second call, if any, the eligibility criteria and other considered first notice of inviting are required to be reviewed by the tendering authority. Then, my lord,
Last line, T-tender.
my lord, under such circumstances, last first paragraph, my lord, under such circumstances, has you lordship got it? First paragraph.
This is memorandum dated 14th February
Yes, this is 14th of February.
2017.
Yes. My lord,
Where are you reading?
my lord, first, starting from first paragraph, my lord. As per, my lord, I am just, however, I am now coming to my lord second, however, has your lordship got it?
In case of second call.
Yes, however, in case of second call, if any, then however, my lord, after this 1, 2 and 3, however, it has been observed that in many cases, the above provisions and procedure of reviewing the eligibility criteria and white publications in the second call are not being properly observed by the tendering authority. And also in some cases, extending the time of after the expiry of the normal time is regarded as equivalent. Under such circumstances, in partial modifications of such and such, the relevant orders issued in this, the following provisions regarding extension of last date, the acceptance of bids when the numbers of qualified bidders during re-tender is less than 3 are to be followed. Then II, 2, if the number of qualified bidders during the tender return is less than 3, the tender unit shall take a decision based on following situations. If number of qualified bidder is.
What is the value in your case? Above 5 lakhs.
Yes, no, it is more than, my lord.
So it will be under clause B.
B. B.
What does it say?
My lord, if number of qualified bidder is 1 during the tender, if the bid is within 2% of the above estimate and department head secretary accepted the tender, if the bid is beyond 2% above estimate,
The consultation of the financial advisor of the department will refer to the file to the finance department. Then if number of qualified bidder is 2 during, my lord, here they are claiming to be number 1 on the basis of that notice. And that was the only basis of the, kindly now take the single judge's order, my lord.
Where is the finding?
Yes, my lord, order starts from page 71.
No, you take us to the relevant.
Yes, now kindly come to page 74, paragraph 8. Now it will be tallying with your losses.
The process of inviting.
In the process of inviting further documents to cover up the technical deficiencies of the other 16 bids and subsequent approval of 4 out of these, my lord,
it is prior.
Prior.
It is not subsequent.
Not subsequent. With the petitioner by drop, on the above grounds, the learned senior counsel appearing for the submit.
No, before that, page 44.
Yes. My lord, 37 is the technical evaluation.
Wait. Don't be in a hurry. You are thorough with facts. See if it is
five bidders. My lord, it should be page
43.
44 now in stay application.
All right. That is financial bid opening summary.
Yes.
It was uploaded on 26th of November 2020.
Yes.
But the shortfall documents proceedings is dated 10th of November 2020. It was prior to that.
No, my lord, it was opened on, my lord, it is updated on 26th November. My lord, opened on, my lord, 10th September.
Where do you get it?
My lord, page 42. Page 42, middle. Technical bid open summary, that is the heading.
Wait.
Page 42, the stay applications in the middle.
Opened on 10th September.
September 2020.
So as on 10th September, they finalized 5 people.
Only 5 people.
And why they called for additional documents from all six?
And why should all be notified? My lord,
except the writ
except him. My lord, that is, my lord, the suspicion remains in my mind also. And that was the sole ground, my lord, for. And you also will find the checklist, my lord, the documents which was asked for, that the local address of the bidder, that was already shown to have been furnished in the checklist. You also will find from the shortfall, local address and proof of. Now you also will kindly come to the checklist once. My lord, address, well, these are the 1, 2, 3, 4, 5, 6, 8th column. So found to be okay in respect of 5 bidders.
Ultimately, successful.
My lord, I had submitted a bunch of, my lord, relied upon judgments, my lord, I don't.
You retain it with you. Yes. That is on the interpretation, how to interpret the terms of contract.
This type of contracts, my lord, and a successful bidder.
Yes, sir. On facts, you please tell us. We'll not go in. So first problem is not impleading that they are guilty, but the learned judge has rendered a finding. We will consider the correctness of that finding. Now, what made the department call for additional documents or shortfall documents from 16 out of 17 bidders, except the writ petition? That explanation is required. Because much prior to that, you have already shortlisted and found 5
May I
of
just
them.
take your lordship through the sequence of events as appearing from the records before your lordship? Perhaps there's a little bit of dissimilarity in the way I will approach the issue, but ultimately I am supporting the appellant that he has been rightly given the contract but perhaps his approach insofar as the appeal is concerned will be a little different from mine. Now, the relevant provision under which we sought documents is at page 19, clause Roman 7. It's actually clause 4. This is part of can number 2, can 2, can 2, which is a stay application.
Yes,
Page 19, Roman 7, copy of proof of residence of the agency. Contractor like photocopy of EPIC, telephone bill, electric bill, bank passport, and office working unit within district of concerned hospital.
Yes.
This is the concern clause with which we are all concerned. But the state has taken a call that this is not an essential condition of the contract. This is an ancillary condition. Therefore, if there was any deficiency in providing these details, we could have asked for it. And if it is provided to us, the defect is cured. That's a stand the state has taken on interpretation of its own documents, which Supreme Court, as your lordships knows, it is within the exclusive province of the state. Now, my lord, one further clause, if your lordships please see at page 23, which permits draw of lots, because that also assumes some importance. Page 23, the last line. That's clause 33C. Perhaps no other clause of the tender documents are important except these two clauses. Now, my learned friend is correct in saying that the technical bids were opened on 10th of September 2020. That date is correct, and Lord, I also stand by that date, 10th of September 2020. But the next thing that happened is, Lord, the document at page 46 is the document by which we asked for the shortfall documents. That's 10th of November 2020. So after opening of the technical bids, when we found that there was deficiency in furnishing the documents as per that clause which I showed your lordship with regard to proof of address, we gave this letter on 10th of November 2020 at page 46, asking for all the bidders who had not supplied the document to furnish this.
But what was the need to do that? You had already shortlisted.
We had not yet. I'll just, because there's a difference between the dates which were shown to your lordship. I'll just indicate that, Lord. I'm just taking your lordship through the sequence. So 10th of November 2020, we asked them to furnish additional documents. Your lordship will find that page 46, you are requested to upload the above mentioned documents in e-procurement website within 20th November 2020. Thereafter came in sequence the comparative statement at page 37. This comes later, not earlier. Please see the comparative statement. Please see that heading. Comparative statement of necessary documents submitted by the bidders in respect of retender for SHF, dated 25th June 2020, which has been opened on 10th September 2020. Now, look, this comparative statement is being prepared after receipt of the documents on, your lordships will find the date at page 40. The date on which the members of the tender selection committee signed, which is 26th of November 2020. So therein lies not the difference between my learned friend's sequence of events and what actually happened. So first, the documents were submitted. We opened them on 10th of September. We found deficiencies. We took them to be ancillary conditions, not essential conditions. And we gave notices to the deficient bidders that you please supply the documents. They supplied their deficient documents. And thereafter, we prepared this comparative statement. And your lordship will find this is further reiterated from the heading of the chart. Now, please take the names of the columns. First is names and addresses, catering license, GST, PAN, TAN, professional tax, etc. Then please see the next column. It's divided into two parts. Please see the top of that. Shortfall documents submitted by the bidders against our update in website dated 10th November 2020. Only thereafter this chart was prepared.
So,
after this chart was prepared,
yes, in spite of this opportunity, serial number 1, 2, and 3 did not upload.
Yes, Lord.
Fourth was not called upon because I think he is already uploaded.
Absolutely, Lord. Absolutely.
So fifth had uploaded.
Fifth did not upload the proof of residence. Then we find that 11 and 13 have uploaded. That's Jana and
So
Frantik.
you found serial number 4,
4, 11,
11, 13,
and the next page, 14 and 17.
14 and 5 people.
These are the 5. So these 5 were the shortlisted candidates whose bids were opened in the financial bid, which is at page 44 of your Lordship's brief. These 5 were opened and we found that the bids were exactly the same. So these 5 were called for
lottery.
The lottery.
And he was successful.
And he was successful. He did not come for the lottery.
He didn't attend.
Did not turn up for the lottery.
Why cooperative society didn't?
Now he comes and says, since notices were issued to all except for me, it implies that I was the only successful bidder. They were all unsuccessful. That is the case made out by my learned friend before the trial court, that every other bidder was actually technically deficient. I was the sole bidder who complied with technical requirements. This is what happened.
Yes, sir. On facts.
On facts, my lord, this is the.
But is it a fact that you did not participate in the lottery?
No, first of all, my lord, that 10th November notice, which has been made after the opening of the technical bid. My lord, this is a 2-bid system pursuant to the notice.
That finding is in your favor.
Yes.
The learned judge's finding is in your favor. That we have taken note of.
This is a 2-bid system, my lord, and they have to qualify. Every bidder is required to be qualified in the technical bid first, later on the financial bid. So it appears apparently from their notice itself that out of other than me, all other.
Nobody is qualified.
Because this is a rectification of errors, my lord, which has been permitted by the state, whether it is permissible in law or not.
That is why the learned judge says to cover up.
Yes.
Judgment.
The process of inviting further documents to cover up the technical deficiencies of the other 16.
Because, my lord, when the bid is being summarized and it has been submitted by the bidder, that is the final form, and there is no further.
But then let us keep that aside. But ultimately, all 5 people were shortlisted.
My lord, first of all, they have to disclose that when the bids were opened initially. Bids were opened by the authorities initially on 10th September. That means the 16 bidders, all these 16 bidders were not qualified. As because if this 10th September event is being made properly, then the question of 10th November notification could not and does not arise.
But if the tender conditions permit the authority to call for shortfall documents.
Yes.
Or call for certain documents, which in the, that's why.
That is the copy, that is called for shortfall documents, my lord, that is at. This is, my lord, that is the what my learned senior friends shown, my lord, that is the clause 4 of the 4 at page 35. The technical bids. First column is earnest money, second is third form are the professional taxes and alls, and 7 copy of the proof of residence. Where is it is not here mentioned that after tendering the technical bid, this shortfall document, the copy of the proof of residence.
That is their argument is, this is a non-essential condition.
No, my submission is that, my lord, technical bid comprising from the Roman 1 to Roman 9 document. So if the bidder is to be qualified, that is to be taken at the first instance, and the shortfall document which has been omitted or not given, they are not to be given a second chance.
All right, let us accept your argument. Then your case should be that you are the sole and successful person.
Technical bid.
And when they notified 5 people saying that these 5 are qualified and their bids are identical in terms of the conditions of tender, I will be drawing up of a lottery or a draw of lots. You should have filed immediately challenge that decision, saying that I need not participate.
Actually, my lord, the writ petition is not annexed here, my lord. In the writ petition, we have made the representation.
But you should have participated in the draw of lots. Especially
Milord,
when the-
participation is subject to correction, Milord. I am asking myself, when the procedure is not following the fair play and justice, Milord, and it is apparent from these technical bits, what my learned senior friend submitted, that shortfall, they are not from any tender document. They are not even permitted to call for shortfall document. So 10th November notice, it's expressly bad in law.
Suppose you say that he has not submitted his catering license. He becomes wholly ineligible.
Yes.
So what was the shortfall was with regard to the address? Huh?
Milord, that is required because, Milord, your lordship knows that those judgments were made by the recent Supreme Court in 2021, and Milords, Milord, the conditions of the contract and Milord, the covenant of the contract cannot be interpreted, Milord. And it is apparent from the covenant of the contract that the state cannot call such notice.
Now, catering license for supply of cooked will definitely contain the address of the
Yes,
licensee.
yes.
What they want is copy of proof of residence of the agency or contractor, like telephone bill, electric bill, etc. It is the residential address of the agency.
That is after that which enable them to make the entire bit uploading afresh.
No. So what will be an essential condition? Admittedly, the contractor, let us say you are a cooperative society.
Yes.
In a cooperative society, you will have your registered address
Yes,
in the certificate of registration, no problem. In the license also, your address will be there. The secretary or manager would have furnished his residential address. So there is no problem. The other person, let us say, what is it called? Jana Enterprises. He is a proprietor.
Yes.
So the license is in the name of the proprietor.
Yes.
I don't know why they are asking for residence address.
Lord, if your lordship sees the checklist at page 27, Lord, exactly as my lord, the Honorable Chief Justice described, page 27, the checklist, all the documents from 1 to 8 will have in one form or the other the addresses. Number 9 is the proof of residence, which we said is an incidental term. It's not an answer.
Actually, the proof of residence of the contractor.
To show that he is a resident of that particular district where the hospital is situated.
But how does it matter?
It's a matter of convenience. We must, the hospital must be able to
If
approach.
he has obtained a license from.
Lordship is absolutely right. It's a non-essential condition, which is why we allowed deviation in terms of both the state.
You should have implemented. And that finding we are not agreed. By the learned judge saying that this is non-impleading will not. Obviously. All right, we'll consider. Come.
Milord, this is the checklist. Without the filing of these documents, the bid cannot be
That we'll
considered to
consider. That we'll consider. This intra-court appeal by the.
I relied on Podda Steel for liberty to vary from the essential terms.
By a third party to WPA 10
paragraph 6
800 of 2020 challenges an order passed by the learned single bench dated 5th January 2021 allowing the writ petition filed by the first respondent herein, which is a cooperative society. The appellant was awarded the contract for supply of cooked diets to the indoor patients of ESI hospital. And an agreement was entered on 8/12/2020. And the period of supply was for 2 years from the date of signing of agreement. And the tender conditions also provided for extension of 1 year on the expiry of the scheduled time at the interval of 6 months each, provided the agency agreed to comply the extension order, maintaining the same quality and quantity of the diet with same terms and conditions. In terms of the date on which the agreement/contract was signed, the appellant was entitled to continue the supply for a period of 2 years, which was to come to an end on 5/1/2021. 2021,
5th December 2022.
2022,
5th
December 2022,
7 December 2022.
7 December 2022. The contract, prior to signing the agreement, letter of acceptance letter was issued by the department in favor of the appellant in the name of his proprietorship concern, namely GS Enterprises, by proceedings dated 7/12/2020. And the appellant had furnished the security deposit on 8/12/2020, being a sum of rupees 3,50,000. It is thereafter supplies are said to have been commenced by the appellant, and the writ petition was filed by the first respondent cooperative society, challenging the said award of tender, and seeking for a declaration that the writ petitioner has to be awarded the tender as he is the single qualified bidder in the tender process. The appellant had sought for leave from this court, from the division bench to file this appeal, since the appellant was not impleaded as a respondent in the writ petition. The writ petition. Thus, we have writ petition. It has to be seen as to whether the learned writ court was justified in right in allowing the writ petition by holding that the award of tender in favor of the appellant was incorrect, and that the writ petitioner was entitled to be awarded the tender. Full stop. After we have elaborately heard the learned advocates for the parties, we are unable to persuade ourselves to accept the finding recorded by the learned single bench that the appellant need not be heard in the matter. The effect of the order passed in the writ petition is that the tender awarded in favor of the appellant has been interdicted or has an effect of cancellation of the tender. Thus, the principles of natural justice mandate that the appellant should have been heard. Therefore, the finding of the learned single bench that non-impleading of the proper and necessary parties will not disentitle the writ petitioner to relief. Non-impleading of the proper and necessary parties does not hinder the disposal of the writ petition in their absence is a finding which requires to be set aside, and accordingly it is set aside. Reverting back to the facts of the case, we need to consider as to whether the learned writ court was justified in arriving at a conclusion that the first respondent writ petitioner was the sole tenderer who had satisfied all the terms and conditions of tender. The tender notification contains the terms and conditions for supply and service of the said items, and clause 4 of the terms and conditions deals with the technical bids, and it contains 9 subclauses. There are totally 17 entities/persons who had participated in the tender process, and the technical bids submitted by the 17, which include the writ petitioner, the appellant, and the first respondent writ petitioner and others. The technical bids were scrutinized after it was opened on 10/9/2020. After it was opened, the tender evaluation committee, consisting of the medical superintendent of the Durgapur ESA Hospital, the general duty medical officer Durgapur ESA Hospital, and 2 general duty medical officers also, and 2 officials of the administration, formed the tender scrutinizing committee. The documents which were furnished by the tenderers were scrutinized, And during the scrutiny process, it was found that out of 17 bidders, 16 of them had not furnished the requisite information called for in clause Roman 8, small 8 of clause subclause Roman 8 of clause 4 of the terms and conditions of tender. The said condition is to produce copy of proof of residence of the agency or contractor, like photocopy of telephone bill, electric bill / bank passbook, and have an office / working unit within the district of the concerned hospital. In the opinion of the tender scrutiny committee, this condition, this condition was a non-essential condition, and therefore, in their discretion, they thought fit to afford one more opportunity to the 16 tenderers to furnish the document to satisfy the requirement under clause 4 within bracket 8 of the terms and conditions of tender. Accordingly, notice dated 10/11/2020 was issued. As mentioned earlier, the writ petitioner was not included in the said notice, as it appears that the writ petitioner had fulfilled the requirement in clause 4 within bracket Roman 8 of the terms and conditions. Pursuant to the notice issued calling for shortfall documents dated 10/11/2020, several of the bidders had submitted the documents, the document, which includes the appellant. Thereafter, the tender scrutiny committee evaluated evaluated all the documents, and on 26/11/2020, drew a list of the eligible tenderers who were found to be qualified. Among them were the first respondent writ petitioner, the appellant, and 3 others. This list was drawn and notified, showing that 5 entities are qualified in the tender. And since all the 5 entities were had all quoted the same bid, and all of them were ranked as L1, it became necessary for the tender scrutiny committee to resort to the procedure stipulated in the terms and conditions of tender, namely in clause number 33, which states that 33 within bracket small c, in case of tie of rates, TIE, the successful bidder will be decided by draw of lots. This the intimation regarding draw of lots was intimated to all 5 of the bidders who had all been declared as L1, and in the draw of lots, the appellant was declared as successful tenderer, and the contract was awarded to the appellant. To be noted that the first respondent writ petitioner did not participate in the draw of lots. The argument of the learned advocate for the first respondent writ petitioner is that the condition mentioned in clause 4 within bracket 8 of the tender conditions ought not to be relaxed, and only with a view to cover up 4/7, sir, sorry, 4/7. I was telling 4/8 now. 4/7, Roman 7 of the terms and conditions. 4/7 cannot be relaxed and has been done for certain other collateral purpose. We are not inclined to accept the said submission, since it has been held in several decisions that the tenders evaluating authority or the tender inviting authority is the person who knows who would be the best suited contractor to cater to their needs. That is the reason that the state authorities have been given a play in their joints, inverted comma, while finalizing a tender process. Courts have further held that it is not for the court exercising jurisdiction under Article 226 of the Constitution to interpret the terms and conditions of the contract in a particular fashion, which does not suit the requirement of the tender inviting authority.
Would your lordship like that I should hand over a judgment on this, on this recent judgment?
In this regard, it will be beneficial to refer to the decision of the Honorable Supreme Court in Agmatel India Private Limited versus Resources Telecom Others, 2022 5 SEC 362.
Paragraph 25 onwards.
Wherein the Honorable Supreme Court held
Paragraph 25 onwards, all the judgments are dealt.
wherein the Honorable Supreme Court referred to several decisions rendered earlier and held that the authority that authors the tender document is the best person to understand and appreciate its requirements, and thus its interpretation should be a second guessed. It should not be second guessed by a court in judicial review proceedings. In the opinion of the Tender Scrutiny Committee, the requirement to produce copy of proof of residence and to have an office and working unit within the district concerned hospital, the district of concerned hospital was not an essential condition, in the light of the fact that already the other requirements such as the catering license, GST registration, PAN card number, professional tax license registration, professional tax registration, experience certificate, EPF and ESIC registration, income tax clearance, etc. Are all essential conditions. Precisely for that reason, not for one of the bidders, but for 16 bidders, opportunity was granted. Therefore, we find that there is no attempt made on the part of the department to cover up any alleged illegality or to favor any set of individuals, any particular individual. This is manifested from the fact that upon evaluation, after receipt of the shortfall documents, 5 of the bidders were declared as L1, and one among them was the first respondent writ petitioner themselves. Thus, we find that the process adopted by the respondent department in finalizing the bid and declaring 5 of the bidders as L1, and thereafter resorting to clause 33 within bracket 3 of the tender conditions and inviting and drawing of lots for selecting the successful tenderer cannot be faulted. Thus, cannot be faulted. Insofar as to how a condition of a tender has to be interpreted, beneficial reference can be made to the decision of the Honorable Supreme Court in Podar Steel Corporation versus Ganesh Engineering Works, 1991, 3 SEC 273, wherein the Honorable Supreme Court held that the requirement in a tender notice can be classified into two categories: those which lay down the essential conditions of eligibility and others which are merely ancillary or subsidiary with the main object to be achieved by the condition. Full stop. Insofar as the essential conditions, the authority issuing the tender may be required to enforce them rigidly. And insofar as the ancillary or subsidiary conditions, it will be open to the authority to deviate from and not insist upon strict literal compliance of the condition in appropriate cases. In the case on hand, the tender scrutiny authority committee did not dispense with the requirement under clause 4 within bracket 7 of the tender condition, but directed the document to be supplied, which were not supplied by 16 tenderers. Merely because the writ petitioner had supplied the document, they cannot come to the conclusion that they have been declared as the sole successful bidder. This is so because the evaluation of the tender took place much thereafter, and the tender scrutiny committee had finalized the bids only on 26/11/2020. Therefore, certain factual errors have also crept in, which had crept in while deciding the writ petition. The writ petition, full stop. Thus, for remove that factually. Thus, for all the above reasons, we are fully convinced that the order passed in the writ petition calls for interference. Accordingly, the appeal is allowed, and the order passed in the writ petition is set aside, and the writ petition is dismissed, and the appellant shall be permitted to commence supply of the items for which tender was awarded in his favor, and the period of the tender shall be computed from the date on which the supplies are directed to be effected, after deducting the period of 1 month, roughly about 1 month, for which the appellant had effected supplies.
I'm grateful, my lord, extremely.
My lord,
I'm also
the
grateful to my
period of the contract has already expired, my lord.
Sir, in that Agmatel judgment, you had
Has been further held in Admatel India's private limited sutra that if the interpretation given to the tender document by the person inviting offers is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering with the interpretation.
My lord, the period of the contract is already over, my lord.
that of signing the agreement.
Yes, that is for the 2 years, my lord. That is already over on.
Yes, because interdicted by court order. Next. Thank you.
Grateful.
Your Lordship, I am appearing on behalf of the appellant, and I have received information from the instruction from the client that he would not like to proceed with the instant appeal.
Any written instruction?
Yes.
You give that, we'll record that to safeguard you. The learned advocate.
Your Lordship, please turn over for the English translation.
Learned advocate for the appellant has produced a copy of a written instruction given by his client, Mr. Tapan Giri, that he does not wish to proceed with this appeal, which is pending before this court, and seeks for withdrawing the same. Accordingly, recording the said letter and directing the said letter to be kept on record, the appeal is dismissed as written.
Gratefully, Lordship.
My lord, the
Kept
advocate
on-
have taken chance. It was some previous advocate. They have taken chance in favor of Mr. Pal.
No objection from the previous advocate.
What you should do, you do.
Grateful, your lordships.
Next,
Serial number 3.
specially fixed matter.
My lord, in this matter, Mr. Siddhartha Banerjee is appearing in this matter. He is the code number 13. My lord, kindly pass over. Pass over, my lord, kindly.
330 no
My lord,
pass.
not to remember pass over, my is kindly, my lord.
330 no pass over.
Kindly not today, my lord.
Not today, it can be done.
My lord, he is coming, my lord, is the code number 13, my lord, kindly.
What is the matter? You tell us. Agreed by the order of the district magistrate Murshidabad. Stamp printing license. Where is that order, sir? You show that order.
This is no pre, my lord.
Impugned order is at.
Kindly, my lord.
You have been mentioning. Thereafter, we put the matter. You are coming without brief.
I have not Siddhartha Banerjee is my senior, my lord.
Maybe.
Senior.
I'm sorry, my lord. I thought, my lord, the previous.
Where is the impugned order of the district magistrate rejecting your application?
Yes, my lord, the.
At page 75, my lord.
Yes.
In the
75.
application.
Thank you.
75 is not.
No, it's not 75. It's not 75.
Yes, 8th order.
চলবে। The order appears at page 99.
99.
Bhojapur.
Earlier, you had filed some writ petition.
Yes. My lord, in that writ petition, my lord, an order was passed, my lord, directing the authority concerned, my lord, to consider my lord, prayer and to pass a resent order.
Disability pension is.
Yes.
In
My lord,
compliance
I
with
prayed
solemn
for, my
order,
lord,
so and so, copy of so and so came up for hearing. Written state.
Full matter. 72.
What was the last date in the advertisement?
my lord will kindly get that, my lord, in the advertisement itself. My
No,
lord,
you just give the date.
my lord, I need to see, my lord, the
Your
advertisement.
junior should have prepared some dates and events and given me.
That's my responsibility, my lord. May I just indicate, my lord, from the
His
advertisement.
application was dated 1/6/2018.
Correct.
The advertisement was issued on 16/3/2018.
Correct.
What was the last date?
The
Last date is
16th March 16th March
2018.
2018. My lord, at page 72.
Last date.
Yes.
So he gave his application
Within that date.
3 months.
Within that date.
But they point out some discrepancy in the.
Yes. Milord, in my Milord testimonials, Milord, my certificate, my registration certificate, admit
Senior
card.
secondary school.
Yes, Milord, there were Milord some typographical errors, no doubt of that. Milord, I applied Milord before the authority concerned for Milord correction of Milord those typographical errors which have been done. Milord, those.
Then you'll have to wait till the, see now, everywhere the stamp vendor's license which have been expired
Yes,
has not been renewed throughout the country.
Milord, I can
After
understand.
e-stamps have come, I find most of them are e-stamping.
Milord,
That has been referred to in my evidence.
All registration also, in the registration department
True.
also, everything is e-stamping.
Yes,
Except for this advocate welfare, clerk welfare stamps. We don't buy those labels.
True.
Anymore, you don't
But I
buy
can
those
follow.
labels.
Milord,
But what we can do if this mistake in the certificate was rectified,
those are now rectified.
you apply as and when they open the window, they will consider.
Milord,
Are you getting disability pension?
as of now, yes.
Yes. Be happy with that.
Yes, as of now, Milord, yes.
And see, it's not, what is the nature of
Milord, may I, Milord, try and join issue there so far as Milord this requirement of stamp vending license? Milord,
can't,
once Milord they issue an advertisement, Milord, they cannot say that Milord that advertisement was superficial and Milord we really Milord did not Milord require a stamp vendor.
No,
Milord,
that
whether
is-
or not
you can be non-suited on the sole ground that your application was beyond time.
it was not, Milord, I can show from Milord the records.
1/6/2018, that's what the district magistrate says.
My Lord will kindly take the trouble, Milord, to have a look at Milord 3 papers, Milord, annexed to my Milord application. Kindly Milord turn to page 72 once. 72, Milord, is the advertisement. Milord, though Milord, this is written in Bengali. Milord, the second paragraph indicates the last date of submission of application 16th March 2018. Milord, it reads as Milord Agami 27th February 2018 to 16th March 2018 applications had to be submitted. Now, if my Lord kindly Milord turns over the page. Kindly, my Lord will kindly take Milord page 73. Milord, there is Milord a receipt at the foot of it, Milord, on the left hand side. Milord, the date is given. It is Milord 15th March 2018.
So you have submitted within time.
And Milord, I submitted twice. Milord, page 73 is 15th March and page 74 by post. Milord is on 5th of March. Milord, the receipt is there. Milord, there is a stamp and a date is put Milord on towards the right hand side. Not Milord happily legible. Milord, this is 5th of March. So Milord, well within time. So the first ground Milord goes. This Milord contrary to what Milord surfaces from the records. Now, the second point was, Milord, these discrepancies in Milord my
That you have made a correction.
Yes, Milord, there. I have Milord prepared supplementary affidavits to that effect. If my lords kindly permit me, Milord, I can Milord file.
Yes, ground pleader, we'll send it back.
Yes, Milord, kindly do that, Milord, I will be happy.
By the, and what happened to your writ petition?
Milord, the previous writ petition was disposed of with a direction, Milord.
No. This
Milord, that impugned order, my Lord, will kindly find at page 113. Milord, to some extent, the Honorable Single Judge was with me.
But we were also. See, it's a very serious matter, no? School, secondary school certificate, there's discrepancy.
So, Milord, there was a suspicion whether I tampered with, whether I made a false declaration or not. But, Milord, those, Milord, confusion are now dispelled.
This intra-court appeal by the writ petitioner is directed against the order dated 13/9/2021 in WPA 8583 of 2021. By the said writ petition, the appellant had challenged the order passed by the District Magistrate Murshidabad dated 11/3/2020 rejecting the application rejecting the application made by the appellant for grant of stamp vendor license. This is the second round of litigation. And in the earlier round, there were two sets of litigation. One where the petitioner, being a differently able person, was not sanctioned the disability pension. Ultimately, directions were issued in an earlier petition, and we are informed by the learned advocate for the appellant that disability pension has been restored. The appellant had applied for grant of stamp vendor license.
But I'm sorry to interrupt. That submission I made, Milord, on instruction. Milord,
On instruction.
It's
Stamp vendor license pursuant to the notification issued on issued. Pursuant to a notification issued by the department, and the last date of submission of the application was 16th of March 2018. The appellant had submitted his first application on 5th of March 2018, as could be seen from the from Annexure P appended to the stay petition, which shows the seal and signature of the Murshidabad Collectorate.
District Magistrate and Collector, Milord Murshidabad.
Collectorate.
Collectorate. Stand corrected.
Murshidabad Collectorate. The petition, the appellant also relies upon a postal acknowledgement card, which shows that the cover was delivered on 5/3/2018 in the office of the district magistrate.
But the first one is 15th, not 5th. Second one is 5th.
First one is 15th.
15th. Second one is Milord 5th. Page 73 is 15th. Page 74 is 5th.
There is nothing on record to disbelieve the stand taken by the appellant. And therefore, we are of the view that the application submitted by the appellant ought not to have been rejected on the ground it is been submitted beyond the cutoff date, that is 16/3/2018. The other aspect on which the district magistrate refused to pass orders in favor of the appellant is with regard to an alleged discrepancy in the Delhi Senior Secondary Open Education Board registration card. The petitioner has filed the appellant has filed a supplementary affidavit dated 17th February 2023, stating that the mistake which had occurred had been duly rectified and certain documents have also been appended along with the supplementary affidavit. It is for the authorities to now verify as to whether the stand taken by the appellant that necessary rectification has been made to correct the mistakes is acceptable or not. And in this in a proceedings under Article 226 of the Constitution, such an exercise cannot be done. In the light of the above finding, that the application submitted by the appellant has to be treated to be within the time stipulated, we are inclined to set aside the order passed by the district magistrate Murshidabad and remand the matter to the district magistrate for fresh consideration. Though in the impugned order passed by the district magistrate, it has been stated that that you use that practice of using stamp paper is going to be abolished. Till date, no such order has been passed by the state government abolishing the use of physical stamp papers and stamp labels.
Not to my knowledge, Milord. Not to my
full stop. In any event, since the application has been directed to be considered at fresh, it is deemed that such an application was in the application was validly submitted in the year 2018 pursuant to an advertisement issue. Therefore, any subsequent decision can have no impact on fresh consideration of the appellant's application. In the event the government takes a policy decision to abolish all the licenses issued to stamp vendors, it is at that stage, Stanford does, it may be a matter which will be applicable to all such Stanford does throughout the state.
Grateful to your lordship. Yeah.
In the light of the above, the appeal is allowed, the order passed in the writ petition is set aside, and consequently the order passed by the district magistrate is set aside, and the matter is remanded to the district magistrate for fresh consideration. The appellant is directed to submit a fresh representation along with a copy of this judgment and order, enclose all the documents in support of his claim that a mistake which occurred in the
testimonials
senior secondary open education board registration card has been duly rectified, and upon receipt of the documents, the district magistrate shall verify the same and consider the application submitted by the appellant for grant of Stanford license afresh on merits and in accordance.
May it be a time-bound exercise.
The above direction be complied with by the district magistrate within a period of 12 weeks from the date on which
so grateful
the appellant submits the representation in terms of the aforementioned direction.
Extremely grateful. To
So for that two documents, page 73 and 74 is concerned, let also that document is also be disclosed with this document, with this letter. Why I'll tell his lordship, in the affidavit, Millard, we have categorically said, Millard, from the note sheet, it appears that it has been submitted on 1st of June. So, Millard, let that be also be, and that has not been denied in
the appellant is also directed to enclose all other documents in support of his claim, including the documents to substantiate that the application was submitted in person on 15/3/2018 and sent by registered post and received in the office of the district magistrate on 5/3/2018.
Get it. Original AD card, original.
Serial number 4.
Grateful. Grateful.
I appear for the appellant writ petition. May it please the lordship, and I am led by Mr. Kishore Datta.
He is appearing online.
I'm here for the response.
Well, at two grounds, precisely. Mr. Datta has come in.
Yes.
Millard, Millard, we have given him a short list of dates made on the last occasion. If your lordship may kindly have a look to that.
Short list of dates.
Yes.
Yes. The tender was floated on 31st of March 2021. We had tried to avoid very many dates. I'm sorry, 31st of March 2021, Millard, the tender was floated. Millard, we participate, and Millard, we are the successful bidder. Millard, 10th of December 2021, Millard, the first date, Millard, the letter of acceptance is issued. Now, the period to do the work is 6 years from the date of letter of acceptance. Now, kindly keep in mind, Millard, the nature of the work is open cast mining. This is very important. I'll demonstrate why this is very important.
Then, my lord, on 16th of December, my lord, the next serial number 2, the appellant, my lord, accepted the letter of acceptance. My lord, on 28th of December, I submit the bank guarantee of 2.60 crores. My lord, this is performance guarantee. Then, my lord, on 31st of December, I request for issuance of the work order. My lord, January 10th, my lord, the work order was issued to me. Then, my lord, 10th of January itself, my lord, I accept the work order. And 12th of January 2022, my lord, the agreement is executed between the parties.
Yes.
But after about 7 months, that is on 18th of July, my lord, the respondent asks me to attend a joint measurement. My lord, there are 3 letters, 18th of July, 22nd of July, and 13th of September. My lord, by that time, my lord, I could learn that, my lord, the respondent were not otherwise ready with the project. Why, my lord, I'll demonstrate later on. Therefore, my lord, on 11th of August 2022, my lord, I request for foreclosure of the contract. But there are 3 letters. By 11th of August 2022, 22nd of September 2022, and 12th of December 2022. Then, my lord, now kindly take, my lord, page 560, that is volume 3. Why I say, my lord, they were not project ready. Please take page 560.
Now we are hearing the appeal itself, is it?
Yes, my lord. I have enjoying a interim order, but, my lord, the problem is, my lord, they are taking all steps possible, because, my lord, the Honorable Single Judge, my lord, has not accepted my case that there is a supervening impossibility to carry out the work. But in a gist, I'll tell you, lordship, what is the supervening impossibility? Number 1 is, my lord, there was no environment clearance, my lord, when, my lord, the tender was floated. My lord, the environment clearance came this year, that is 2023, after the filing of my writ petition. This is number 1. Number 2, my lord, the project was for a open cast project, but, my lord, the permission to do it as an open cast project, my lord, only came, my lord, after filing of my writ petition. Number 2. Number 3, the tender which was floated, or the work order, my lord, which was awarded in my favor, was for 6 years. My lord, the project proponent, my lord, in the application by the appropriate authority, have reduced it to 5 years, from 6 years to 5 years. This is the third aspect. The fourth aspect of the matter is that, my lord, in the clearance certificate, my lord, we have been injuncted from using the village roads, not for the purpose of transport of the extracted coal that we are going to Delhi. And the fifth aspect, which is admitted, that, my lord, part of the, my lord, area where I am to work, my lord, has not been acquired. My lord, there are busties, there are other difficulties over there, and bricklins. Because this is an open cast mine, my lord. If there's a bricklin, my lord, I cannot do it. Now, my lord, these are, my lord, a few situations, my lord, for which, my lord, I sought
But
to.
then, on the date when you submitted your offer,
yes,
this would have all been in black and white, because there should have been a disclosure. Environmental clearance, whether it is pre-commencement of the project or post facto, that is one issue. Because now there are a lot of notifications issued by the Ministry of Environment Forests, relaxing the norms.
Right.
Including for national highway projects, where they have said that prior enviro clearance is not required, but the project can be allowed to proceed, because by the time you hit the coal, it is going to take some time. And there will be other teething problems of acquisition of land, rehabilitating the displaced land losers, etc.
Right.
So they say, in principle, if the project is approved, subject to 1, 2, 3, 4. Probably suppose they decide, while granting the EC, a public hearing has to be done.
Yes.
This paperwork will not, but this all should have been known to the tenderer.
Yes.
The person, he should caveat emptor.
Well, may I say this, Milord, with respect, Milord? Number one is, Milord, there were no such disclosure. Number two is, Milord.
But at contract of this magnitude,
Yes.
parties are at a different level.
Yes.
It is not that somebody, an individual goes and it's a limited company or a private limited company.
Yes, I'm a
joint venture.
joint venture.
So there must be a national or an international partner.
No, these are all
Indian companies.
Indian partners.
So
Yes.
therefore, you could have sought for disclosure.
No, but this is in my very respectful submission.
Now you have been asked not to do the mining. You can't do this.
Yes, because the Honorable Single Judge has said, has not interfered with my contentions. I mean, not accepted my contentions, and directed that I should be given sufficient time to start the work. If I do not start the work, then whatever consequences.
Without prejudice, why don't you start the work?
My difficulty is that I cannot execute the work anymore.
Why?
6 years is reduced to 5 years.
See, that's all subject matter of negotiation. It's obviously writ court. It's a pure commercial transaction. Now let us assume that you are right in saying that prior environmental clearance is mandatory. They could not have invited that tender.
Right.
Now that issue remains settled, not in dispute. Clearance has been issued.
Right.
Permission for open cast mine also has been issued or whatever it is.
Yes.
But only problem is 5-year term.
And second, the other major problem is that I cannot use the village roads.
That is a nuisance. You have to lay a new road at your cost.
Miller, these are not the conditions of the contract. That is why your Lordship would find, my Lord, there has been a delay on their part of about 7 months.
No. 7 months is too early a time period to seek for foreclosure. Foreclosure, probably they will say that, let us assume, force major conditions, torrential rains for 1.5 years, landslide, or agitation. Public will agitate, will not allow you to enter into the premises in spite of law and order situation. In those cases, you apply for a floor clear. 7 months on and after the letter of acceptance and agreement, you say foreclose means then you are not capable of performing.
Because there were no license with them. But I am already out of pocket.
Best thing is, sir.
Yes.
Instead of fighting with them, you sit across with them. You sit across with them, do some reworking. So probably revision of rates.
Provided they are in a mood to sit with me.
They will not in a mood. They are not in a mood to listen to their advocate.
Now
it is fine. The other day your colleague was so very upset about it.
Since February, Miller, it was the pleasure of the Honorable Single Judge. Please do not take any steps in the meantime. Since Miller, I am hearing the matter. Now the officer changed, Miller, he doesn't know me personally. So it happened. Now, Miller, I have written emails. He has written, Miller, they are not taking any steps.
Now, is there any possibility?
Millard, there was a possibility.
Bad man.
Millard, I showed the papers. I had all license, and in the trial court it's recorded. I have given them, Millard, an option to work. They don't want to work. They want a foreclosure of the contract and refund of their earnest money. That's recorded in the order itself.
Then his remedy is under the agreement, not
yes. And Millard, the agreement provides.
You did not raise the question of maintainability.
Yes, I raised it. This is all raised, detailed order and dismissed, Millard, without calling for affidavit.
Writ petition was dismissed on the ground not maintainable.
No. She Millard said, since I have heard so much, I decide the matter.
You need not hear so.
Yes. Well, there's an arbitration clause, there's a dispute resolution mechanism, there's a commercial court in Asansol, it's a commercial dispute, and Millard, foreclosure, the clause says foreclosure is on the eastern coalfields to exercise that. It's at his option. He says it's my option. How can the
No, he says you exercise the option.
Can it be done, Millard? Can it be, Millard?
But in a writ proceedings, difficult, sir. Writ proceedings difficult.
Millard, today, Millard, the work has been tendered out.
Millard, my client has suffered. It's an unconditional bank guarantee. Millard, I have suffered lots because I did not listen to the courts. Millard, basically what fell from the court. So Lordship has restrained Miller invocation of an unconditional bank guarantee. I also did
No,
not
no,
say.
we can, if client is agreeable, the best thing is to initiate arbitration, file a section 9, obtain some order. Writ proceedings, this can't be.
May I say this, Milord?
The
Post
unconditional
delivery
bank-
of the judgment,
Ah,
Milord, they have terminated the contract. Milord, they have banned me. They have tendered out the work.
So tender is, if suppose subject to risk and cost,
Yes.
that is arbitrable dispute.
Yes.
Blacklisting is arbitrable dispute.
Correct.
Termination is arbitrable dispute. Refund of EMD is arbitrable dispute.
Yes.
Force major, impossibility of performance is an arbitrable dispute. Fraud played is also arbitrable dispute. In certain decisions, they say.
Yes. Now, Milord, at the same time, Milord, your Lordships have also kept the window open that in case there is an arbitrary
Writ
action.
Writ petition should not have been entertained.
Milord, even Milord, in MP Power's case, Milord, one of the latest decision of the Supreme Court, Milord, Supreme Court having noted that ordinarily writ petitions are not to be entertained.
See, that is, suppose in the tendering process, you are able to substantiate there is some gross illegality.
Yes.
Favoritism,
Right.
malice, etc.
Right.
Supreme Court interfered in that grant of this IOC, LPG dealerships, Pan India, allotment of coal blocks. So the
EMTA coal matter. Milord.
yes. So that magnitude court can go into that aspect. But here, was it an impossibility of performance? Did he have the requisite permissions? Did he disclose that requisite permissions, etc.? All these things can't.
It all on record. But nothing, Milord, there is, Milord, in my very humble submission, Milord, there is no disputed questions of fact.
If you want, we can admit the appeal, keep it pending for statistical purposes. No interim order.
Milord, please.
And Lordship has restrained unconditional. It says if he doesn't work, in fact, Milord, the learned judges.
We can tell one thing, we can say that we can entertain the appeal, but however, during the pendency of the appeal, the appellant would be at liberty to invoke the arbitration clause. And we can also say probably for 30 days, this interim order will continue.
This whatever is that, I agree.
That will be better, sir.
I agree.
Please advise your client.
Arbitration na, তুমি bank guarantee invoke করো না.
Termination cannot be satisfied.
Absolutely. I have terminated. In fact, Milord, if your Lordship looks at the judgment, she, Milord, expressed her pains in 10 paragraph.
You should have insisted upon arguing maintainability.
I have argued that. That's taken on record. If an arbitration clause is that it cannot be done, despite, kindly look at the order of the trial court, Milord. Kindly have a look at the order of the trial court. Kindly have a look at the order of the trial court.
But so one thing, if he has to go for arbitration,
yes,
these findings by the single bench should not hurt him.
Well, that's the risk he took. I Milord, argued on Milord arbitrability. That's record. Kindly have a look at Milord Lordship's Milord.
701.
Internal page 3 of the judgment, Milord. Kindly have a look at that.
So otherwise it will become a fait accompli.
Yes.
What is the big point of asking him to go for arbitration? We will say that the arbitral, the dispute will be on
without being influenced by the observations made in the order.
What do you say, sir?
Milord, in that case, Milord, let them withdraw, Milord, the subsequent steps which they have taken after the signature.
That is not part of record.
No, this is part of it. I brought it by way of supplementary affidavit.
Not part of record of the writ court.
Yes, because it has happened later.
Please.
Yes, this has happened later.
So we can't test the correctness of the order on a material which surfaced thereafter.
No, my submission was, since the court desires that I should go for an arbitration.
Not desires, mandates that.
When your Lordship will, pen the order, it becomes a mandate. But before that, Milord,
suggestion.
Kindly look at paragraph 11, Milord. Kindly look at paragraph 11 of the order. Kindly have a look at it. The petitioner shall, however,
Milord, I've been
that option was given to him.
I've been burdened with 65 crores.
Yes.
When they did not have the license. What more arbitrariness will I show, Milord?
No, if
Milord,
suppose, no, your client agrees to para 11 now. Can you not rework?
Milord, I am told, Milord,
See, the cancellation is because you didn't perform. If you say you accept this judgment and I am ready to work, sir, then obviously the cancellation has to go.
Yes, I have below 10, there was below kindly.
It's not an appeal under 11. So
kindly
please preserve this judgment.
Yes, yes, definitely. Please consider one thing, but if the work is tendered out, now I do not know whether any third party rights have been created or not.
Yes, yes.
And at this distant point
Because
of
below 11, the time period, I waited for the time period. That's a time period given to him to work.
Oh.
Well, I did not do it anything within the
No,
time
no, you
period.
invited the tender and you have finalized the tender.
Yes, because below time period, I did not touch it. I did not. He was given an option to work. For 3 years, we have no production of coal. All sites, Willard, at this litigation in writ courts, Willard, all sites are now stalled. I have no coal. I have no coal. And there's a bar under the specifically fact for granting injunction on this.
No. These are not infrastructure projects.
On a
I let
natural
this your lordship
resources
know.
and site judgments.
No,
Willard.
no.
How do I run all
Whenever
sites
Millard,
of
the
this
matter was
are now
taken,
Willard injuncted?
Millard, I am the last person to Millard point fingers at lawyers. But whenever these matters, this matter was taken up by this court, Millard,
I was
adjournments were sought for and Millard, all actions have been taken. And
I
that
really
is why,
don't
on mentioning Millard, your lordships were pleased to Millard pass that interim
Lordship,
order.
as injunction has passed. I have not. Normally, Millard, Lordship knows, Millard, from federal bank, unconditional bank guarantee, there cannot be any. Lordship has restrained it.
Millard,
I'll
so far
continue
as
with
bank
that order
guarantee is concerned, Millard, I have given the bank guarantee at the appropriate time with the expectation that I can work.
I can, Millard,
Now,
invoke
Millard,
it
they
by
do
giving
not
a
have the
notice.
license with them.
Millard, you
and they
cannot.
float a tender.
Lordship knows, Millard, internal disputes between the parties cannot be a grant for
This is
restraint of
there
a
is
bank
no
guarantee.
dispute. He did not have the
That is his
license to
case.
allow me to
Kindly
perform.
look at the order. Kindly look at the order.
Please come. We have elaborately heard the submissions of the learned senior counsel for the appellant as well as the learned advocate for the respondent. By order dated 3/7/2023, we had granted an interim order restraining the respondents from encashing the bank guarantee in question, which has been furnished by the appellant. After hearing the learned advocate for the parties today, we are of the prime facie view that the writ petition itself was not maintainable, particularly when the terms and conditions of the agreement contained an arbitration clause. Therefore, we are of the view that for statistical purposes, the appeal can be admitted. But however, the interim order cannot be continued beyond a period of 30 days from the date of receipt of the server copy of this order, only with the view to facilitate the appellant to invoke the arbitration clause in the agreement if they choose to do so. In the event the appellant invokes the arbitration clause and seeks for appropriate remedy under the provisions of the Arbitration and Conciliation Act 1996, the observations made by the proceedings shall be proceeded with uninfluenced by any observation made by the learned single bench in the impugned judgment and order.
But only one prayer, Millard. If your lordships may kindly have a look to the supplementary affidavit of 10th of July 2023. Yes. But please take this, Millard. Your lordships would find, Millard, at page 6, there is a letter of 26th of June 2023. This is post delivery of the order on judgment under appeal.
Yes.
Now, please take, Millard, by this, but if your lordships may kindly take me at the next page, that is page 7, bottom. Hence, as per directives of the competent authority, following may be noted as order with respect to the contract is communicated. Number 1 is cancellation termination. Number 2 is recovery of damages of 64 crores. And number 3 is debarring. 3 years. Now, this should remain stayed, Millard. Now that Millard, they have tendered out the work to someone else.
Para 11, that was.
The learned senior advocate for the appellant submitted that after the writ petition was disposed of, now the respondents have taken action.
That's
and,
para 11.
And no notice, nothing.
And have passed an order on 26/6/2023,
Notice was given.
by which there is a decision taken to 26/6/2023.
Well, it's page number 6.
Decision taken to cancel this contract awarded to the appellant, recover damages, and debar the appellant, as well as their constituent partners, for a period of 3 years from participating in further tenders. These events, the communication dated 26/6/2023 is admittedly much after the writ petition was filed and much after the impugned order and judgment, which was delivered on 15/5/2023. Therefore, in this appeal, the court cannot make any observation as regards the correctness of the said decision. However, it will be well open to the appellant to invoke the arbitration clause against such a decision if they are so advised. Next.
The last part, I could not follow. I'm so sorry.
This order we cannot test it in this appeal.
Right.
You can, if you want, you can exercise the arbitration clause in respect of these
Of
three.
this 26th
There's a commercial code, section 9. These are all we are getting state.
All CAN applications are dismissed.
Where could I? Sorry.
Next.
Where could I make the pray for this
30
indictment?
days.
Yes, that may not have followed, Miller. So far as this 26 June is concerned, Miller, if my remedy is elsewhere, Miller, I may be allowed to pursue that, Miller.
Arbitration section 9 covers
That risk
everything.
the appellant took by bringing it on record as supplementary. So you can't go before the single judge and say.
Miller, because Miller, this is a sequel to Miller, of the order of the learned single judge, Miller.
My learned senior friend Miller knows Miller section 9 now covers everything.
But there are a lot of private players who are doing. In
Section
fact, I
9.
went and saw an open cast mine.
Yes.
The contractor was Mahalakshmi Enterprises from Bombay.
But in fact, Miller, the Supreme Court, Miller, in that Mahesh, whatever is the name, in that judgment, Miller, had cancelled, Miller, all the coal blocks which were allocated by the screening committee of the central government. And now, Miller, these are again being, Miller, allotted through the process of tender. Section 9 ये तो কেন হবে না? But in fact, Miller, your lordship, the Honorable Chief Justice, I'm sure Mr. Justice Bhattacharya has visited that. The open cast mining in West Bengal, but it's a wonderful thing to see.
No, I went to Asansol.
Yes, yes, yes.
We went to Maithon Dam for a legal services program. And from Asansol, it is about, Justice Bharadwaj only asked me to go and visit. About 45 minutes drive. From the main highway, it takes a left. Beautiful.
Yes.
And we went in their jeep. We went down.
And Miller, the colonies and the quarters of Miller, the managers and the general managers, Miller,
That they didn't
British
take
side,
a-
superb, Miller.
They
I
showed
had an
us-
occasion to see that, Miller. Once of my relatives used to stay. Superb, Miller.
And
Like
they
this
showed
building.
how the coal is being transported through wagons and how they are preventing theft of this coal.
Because it's anyone can taste. It can
It
go
gives
to
that
Sunbath.
impression of those old Hindi movies.
But now it is very sophisticated and they keep spraying water.
Spraying water. Well, because of the environment, Miller.
And so that the dust doesn't
dust
emanate.
doesn't.
Now it will be mechanized, Miller. It will be cutting inside, Miller. Like Miller, with like a TBM machine, Miller. It will cut.
Well, in that Asansol, your lordship will find, subject to manager, that Asia's one of the deepest mine. Deepest mine, well, below the level 120 feet. And it even goes down above the head, one of the river is going on.
Below the river.
Is flowing below.
Below the river, Miller is at 120 feet deep, and this is Asia's deepest mine. That mine.
But underground mining is also, Miller, very
Take
good
after
thing to
physical
see.
checkup, they take. Miller. They do a thorough
But
physical.
in Meghalaya, under the house, there's mining.
Yes.
The Chief Justice there has now taken up the PIL.
I see.
So what they do is they are in the hut on the house. They start mining from the house.
In fact, today, Miller, there's a picture in the newspaper that in between the house, Miller, wires are going, Miller, high tension lines.
As a result, people get caught inside. Only thereafter they start raising.
That's not legal, Miller.
No,
That's
that's not
illegal.
That's illegal
So
mining.
therefore, the public interest petition will be entertained And Justice Sanjeev Banerjee has issued some directions that periodical raids have to be conducted. And the mica mines is also there.
Mica mines.
Mica, where children have been used, because the hand has to be very small to go inside that mining area to pull out.
But that is again another very important source of pollution. And this goes to that portion of the lung through breathing, which no medicine can reach. Only
Maximum span of life is 35 to 40
Yes,
years.
yes.
Beyond that, they are not. In fact, I toured that area up to Purulia, etc. We went into these tribal areas. We organized one program with DVC. Fighting against DVC, they organized the program.
And what Mr. Doctor has said is all illegal by this pollution issues. Now, so far as my information, the Green Tribunal has taken note of that, and they have started proceedings, particularly with regard to these illegal minings. And it is also a finding of the tribunal that is because of its organized crime and with a large conspiracy, and also the ECL and BCCL. There's some officers, all including the local persons, because they do not want the illegal mines to be stopped. And that is why there are accidents, the local peoples are being died.
Parallel economy.
Parallel economy.
These things cannot go forward unless someone inside is involved. Everyone knows we cannot.
We'll stop.
Great.
লিখে দেবে না তুমি arbitration এ গিয়ে নাও আচ্ছা ওটা বলে ইয়েতে ধরে না না সেকশন লাইন তো ছোট কিছু না
Great.